Agenda, unless we amend that. Did that just go on? Yeah. Feedback. I'd like to acquaint you with some of the rules and procedures for conducting this meeting. The applicant and all those speaking in support of an application will be allowed a total of 10 minutes to present any petition. We don't have any petitions this evening, but those in favor of specific ordinances would be the same rules. The opposition to any of the things that we're going to be talking about will be allowed a total of 10 minutes to present its position as well. If time remains, we could entertain rebuttal. Since the burden of proofs upon the applicant, I'm going to skip that part because we don't have any actual applications tonight. Staff of the Community Development Department will be keeping track of time, so we'll inform anybody that wants to speak when their time is running out. Each speaker has to fill out a speaker card before speaking and leave it with a staff member. The speaker cards are back on the counter at the reception desk. All speakers need to identify themselves by name, address, and organization, if applicable, before beginning any presentation. Again, since there are no rezoning actions tonight, Ken, with your approval, I'm going to skip the contribution piece because I don't think it's necessarily relevant. Demonstration of any sort within the chamber is prohibited, so please refrain from any applause, dialogue with the person speaking, or outbursts. No outbursts from the audience, please. Please turn off all cell phones or place them on silent. All remarks will be addressed by the Planning Commission. Please show the same respect to anyone speaking that you would want to receive yourself. Any material that you want submitted to the Planning Commission during the meeting needs to be submitted through staff. And I think that's all we need to talk about at this point. So at this point, we'll open the meeting for public comment. Time will be limited to 2 minutes per person. The purpose of this section of the meeting is for anyone who would like to comment on something that's not on the agenda to come forward and speak. If you have comments about items that are on the agenda, we'd ask that you hold those until we get to those items on the agenda. So, is there any public comment? Seeing none, I would like a motion to move to close public comment.
So moved.
Second.
All those in favor?
Aye.
Opposed? Unanimous. Okay. We have received in our packet the minutes from the November 17th meeting. Are there any changes needed in the minutes of that meeting? No typos? Hearing none, I would like a motion to approve the minutes of that meeting.
I have to abstain.
I move we accept the minutes of the November 17th meeting as presented.
Is there a second?
Second.
Been moved and seconded. Any discussion? All those in favor?
Aye.
Aye.
Opposed? Okay. 6-0 and 1 abstention. Joe, were you here?
No, I have to abstain.
Okay, so it's 5 and 2 abstentions. Okay, Robin, would you call the first order of business, please? Robin, where are you?
Yep. The first item is election of chairperson and vice chairperson for 2011.
The floor is open for nominations.
I'd like to nominate George Ragsdale for chairman.
Second.
Any other nominations? Okay, nominations. We need to move that nominations be closed, I think.
I move they be closed.
Second.
All those in favor?
Aye.
Opposed? Okay. There's one nomination. All those in favor?
Aye.
Aye.
Opposed? Okay. Thank you. I appreciate it.
I'd like to nominate Paul Moore for vice chair.
Is there a second?
Second.
Okay. Move nominations be closed.
I move so moved.
I'm
Second.
assuming there were no others.
Second.
All those in favor?
Aye.
Opposed? Unanimous. Great. Okay. Robin.
The next item is a continued discussion of code enforcement and possible implementation of a code violation matrix. City Attorney Ken Gerard is present at this time to answer any of your questions regarding the topic that we spoke about at the last November
How do you want to get started on this, Ken?
Well, I can approach it a couple of different ways, and I can tell you what my experience has been with these ordinance violation matrices, how they've been implemented in other jurisdictions, or I can simply field your questions as you have them. You may have a specific approach that you want to take, and I don't want to waste your time with a bunch of ramblings that may not have any significance to what the City of Milton's doing. So, Mr. Chairman, I'll do it. I'll approach it however you want to approach it. I could maybe start with where this matrix came from.
Well, let me see if we can't collectively try and frame the question, because I think the matrix was just a suggestion that was offered to us by staff as a possible solution. I think the concern that we had, and you guys chime in, but I think the concern that we had is that we've encountered too many situations where there's not enough teeth in the ordinance to encourage someone who is violating the ordinance to comply with the ordinance. It's much easier just to accept whatever the fine is because it's a one-time fine, it's not recurring, it's not increasing. And what we wanted to do was to find a way to try and build into the ordinance a fine structure that would encourage people who are violating something that is a continuous violation to either correct that or be subject to increasing or continuing fines until the problem was corrected.
Sure. A couple of thoughts on that, and that's a great question and a great concern. You know, it's not lost on me that particularly in some of the development sector, there have been a notion that code violations are simply a cost of doing business, and quite frankly, it's cheaper just to pay the fine and go ahead and move on than to correct behavior. So, you know, and I understand that. You have to, of course, balance that with the notion that with respect to these regulatory fines, particularly, a lot of times the chief objective of the jurisdiction is compliance and not punishment. And so we sometimes have to juxtapose, you know, those competing principles next to each other. Let me offer up this. I think that the Milton Code, the Milton Zoning Code, contains the teeth that you need. The Milton Zoning Code is very express, very explicit, that every day that an offending condition exists on property is a discrete and separate offense. There is certainly case law that allows enforcement action to be taken on a daily basis. There is case law, and I've got it in front of me, that talks about the fact that a offense can be continuing in nature and that an individual could get a discrete citation for every day that that offense occurs. So, in other words, you know, right now under the Milton Code, you have the ability to go out and issue a citation for $1,000 per day per offense. Now, I understand that $1,000 may not get some individuals' attention. I will tell you, it would get mine. But it might not get everyone's attention. But the citation issued on day 2 has now upped the ante. And the citation issued on day 3 is now a real problem. You see where I'm going with this, is that if you issue the citation every day, I think, let me say this, staff, with the advice, I suppose, of the council, obviously with your all's recommendation, could think about doing that. You have to be a little careful, and you would want some input from your judges to make sure how they're going to react to that. Because on the one hand, where I think you could go to the judges and say, look, we are concerned that folks are basically being incentivized to violate our rules because the penalties aren't severe enough. But you also don't want to offend the court and have a court docket of 20 citations for the same offense, all tried en masse, and the court could say, I'm offended by this. You got my attention with one, and I'm going to dismiss the other 19. So I think we would want to get on the same page with our judges to make sure they understand what we're trying to do. What we're not trying to do is overload their dockets with 20 or 25 different citations. We're trying to make sure they have the horsepower to impose a fine that gets people's attention and compels compliance. It would probably only take a couple of months of this and word spreading until people figured out that this is for real and the potential penalties are severe. Now, we've been talking about monetary penalties, $1,000 a day. remember that under the authorizing legislation from the state of Georgia, one of the sanctions that can be imposed on individuals that even violate your zoning code is up to 6 months of jail time. Now, if you want to get somebody's attention, have your solicitor or prosecutor ask for jail time for a setback violation. Now, that will also, there's a political dynamic of that as well, and that most cities don't want to throw their constituents in jail for what is perceived to be a regulatory offense as opposed to what is in its purest form a criminal offense. People understand 6 months in jail for methamphetamine possession. They understand it less for a shed in the buffer area. So you have to compete that as well. But so I guess my point to the chairman is, you have the tools. We have the tools. It's really an implementation issue. That's my point. I don't know that we need to do a draconian overhaul, although we could.
Well, Ken, go back to the beginning, because one of the concerns with the idea of each violation carrying its own fine, in order for that to occur, there's got to be enough enforcement capability to go out and
Well said.
cite people
Well said.
repeatedly as well. And that's part of the concern, is that we don't know that we got enough enforcement capability as we stand now. If that's the case, we wanted to try to get to a place where, and let's use your setback, that if someone's violating the setback and there's a fine, that they could be cited once, but it would continue for that one citation until the problem was resolved, instead of each one being discrete and having to be enforced each time every day.
That's a great question, and I'm not going to be able to sit here and tell you that I know that we can draft the code to allow that. It is the case that the Georgia law provides that our zoning code can provide a penalty for each repetition or occurrence. And right now, your zoning code provides that very thing. It says, any person violating any of the provisions of this zoning ordinance shall be deemed guilty of misdemeanor. Each day's continuance shall be considered a separate offense. Now, what it does not say, and what I have been, and the chairman has now corrected me, is that I am assuming that is anticipating a discrete summons would be issued on that person every day. That's what I'm used to, is that you go out and get a discrete citation every day. That's not set forth explicitly or expressly in your code, so I guess it could be assumed that we could make the argument in front of your city court that it continued until such time as the error or the problem was abated. But again, I think I would want to go to the court, to the judges, and say, look, are we going to get any traction if we make that argument, or are you going to laugh us out of your courtroom?
The other question I had is who's actually assessing those now? My understanding is that those fines are being set by the court, which means that there's discretion, and in some cases, even though it may allow for $1,000 a day, that's not what's happening.
You're exactly right.
Can that be changed so that the fines could be assessed administratively?
What we can do, and that was sort of the genesis of that fine or fee matrix, is that we can adopt that, but the law still allows the court that discretion. We cannot dictate to a judge, you shall issue this. The only thing the judge is going to be limited by is the $1,000 a day, 6 months. $1,000 per offense, 6 months in jail. But again, I think when I started, what I said was this is something that the justices, the judges adopted as well. If we went to the judges and said, look, we want to make this administratively easier. What if someone wants to come in and pay their fine and not go to the court? Well, right now, we don't know what to charge them. But if we have a fine schedule that has been approved by the courts, recommended by the Planning Commission, approved by the council, we all know what the first offense within a certain number of days is. This one works on a 24-month calendar. So the first offense within 24 months is X, second offense is Y, third offense is Z. So that's how we do it, and we could do the same thing here, although I get the impression we want to beat this up a little bit. It's my sense, which we could certainly do.
Not to be punitive,
Well, but again,
unless it's new dancing.
took the words right out. But if we wanted to do that, I think that would be great. And quite frankly, the way you sell that to the judges is it might clear your docket, because if people know that they can come in and pay their fine and not have to go to court, a lot of people are scared to death not of the fine. it's being in a courtroom and having to face the prosecutor. So if they can come in and do that, the judges might say, this is great, this may take the load off my docket.
And if I may add, from the code enforcement field personnel perspective, that is a lot easier, because wherein they may be a little more hesitant to issue a citation when they find a violation the first time, or even sometimes the second time, and try to work with the person more so that they don't have to go to court, because it's just such an iffy thing as to what kind of adjudication they're going to really get, and is it going to be painful, is it going to even be worth all the time and effort they put into building a court case. If they were to be able to just say, okay, this is your fine, remedy it in 30 days and pay this fine, that I think that we would find that to be more effective on her part as well as on compliance.
Ken, if we were to go with something like this, does the idea of the discrete violation, discrete citation become more important, so that the first and second violation do require citations, or would require citations?
And that's another good point. I mean, this code matrix is set up, it doesn't say it expressly, but you would think this would not be a citation on day one, citation on day two, citation on day two. This sort of anticipates that you get a citation, you go to court, you're found guilty, and then you don't fix it. Then you get another citation 3 weeks later. And you see there's a temporal element here that I think you all are trying to accelerate a little bit. You're trying to get their attention a little faster than I think the way this matrix reads. So this is not a cut and paste deal, and this may not work exactly for what you all are trying to work. We may have to work a little harder to get Milton where you all want to be. That's my thought, because I don't think this really would fit within what we're talking about doing. What might be helpful to recommend would be to sit down and try to get with the judges, and try to get the chief judge and maybe the associate judge, meet with the solicitor who's prosecuting the cases, maybe a representative of the planning commission or two, and Lynn and Robin, and let's talk about what our objective is, and let's see if we can get together and see what, because we can talk about this all day, and then I may get over to the judge and it may fall flat, and he or she says, this isn't going to happen in my court. I would rather have input on the ground level of what they're going to be able to tolerate than perhaps spend a lot of time fashioning something, take it to them, and it fails.
Sure. Questions?
Well, just in keeping with that thought, Ken, the judges that we would be presenting this to or in dialogue with prior to any change in effect to the ordinances we have today would be judges that would be friendly to our situation, I would assume. In fact, that those are judges that were either appointed or elected to office by Milton citizenship or mayor and council.
Yes.
So you would think they would fall on friendly ears.
Oh, I think so for a couple of reasons. First of all, it would show that we have a real interest in enforcement. We're interested in what they're doing and how they're running their cases. This is for real. The elected and appointed senior officials of the city of Milton are very serious about this, and certainly they want to hear that. This is not something where we don't care what they do. We care about it. And thirdly, like I said, one huge incentive is that if they feel like they can develop a system where people cannot have to go to court, but yet provide Milton the relief that Milton demands by way of its ordinances, it takes cases off their docket. And there is not a judge in the state of Georgia that would not like to have a little bit of a cleaner docket.
Well, it doesn't sound like there's any cases on their docket now, because it doesn't sound like we're doing any enforcement. So I'm not sure what incentive that's going to really be.
There aren't a lot of
And I don't
citations.
know
There
the
aren't.
answer to that, because my office does not prosecute city code violations, and that's been set up discreetly to do that. So you may be right.
What was that, Lynn?
There's a lot of inspection going on. There's not a lot of citation going on. And some of it is exactly what I said to you. You know, we're trying to work with the person before we give them any sort of citation because of the whole effect of hauling them into court.
Mm-hmm.
Versus if they know they can just pay the fine and remedy it and be done with it, I think that's going to
Yeah, but
be received a little
having
easier.
said that, I mean, there are notable exceptions, right? I mean,
Oh, there's always going to be some.
Well, but I mean grossly notable exceptions. I mean, we had a landscape business come back to us after 1 year of being denied and continuing to operate for a year. We weren't working with them over the course of the year. They didn't come back. I mean,
Well, no, we did. Actually, we had gone out there every couple of months, checking on the progress and.
yeah, but
and-
that's going beyond.
Oh, it's
reasonable.
beyond, but we were also kind of told to continue to try to work with them. So we are going to continue to try to work with them as much as we could until it came back.
I think that's a delicate balance that we have to strike. And we know that as a relatively new city, we desire the appearance of being a friendly city in which to live and conduct business. We want to be attractive to new businesses coming here. We want to thrive as a community with a sense of belonging for everybody. But the difficult part is when, this has been a topic that's been, on the top of my list for some time. And so I engage members of the community, and I engage members both in elected as well as paid positions of our city staff. And I get an overwhelming sense that we have a bit of a frustration level because it is unclear how we want to act and enforce. We have, in some instances, a desire to enforce at the level of contact from enforcement officer and citizen or business, and a seeming lack of support at our elected official level that may be not necessarily as friendly as we'd like it to be. Well, the dilemma there is when you bump into stuff that is clearly a violation, if we have chosen repeatedly to not cite and follow through on the violation, how do we, when there is a gross violation, then as a city act accordingly and not be held in violation of our, or not in violation, but you can probably give better words for that. It's just how do you enforce when you haven't been enforcing? You've set a precedent by not enforcing. So we've got to, I'm not looking for an answer form statement, but it's just the fact that we have to find a better balance. We have to decide what kind of city we're going to be. We know that we've got some violations out there right now, and I'll tell you one that's just an eyesore that I drive past all the time that just gets my goat every single day. And that is we have our friends of Fulton County building a brand new high school not very far from here that has a construction sign or a location sign that's far in excess of our current code. allowing
Absolutely
for.
legal.
It's legal?
Yes, sir.
How is their in excess of 12-foot
The
sign
zoning
legal?
code does not apply to
School district.
the school.
To government. yeah.
Okay.
And therefore
So,
the sign code.
you know,
I'm sorry, I got to stop you on that
Okay.
one.
Okay, I
We've
stand
gotten
corrected.
it
That- As an example, though, okay, if that were a construction site.
Right.
And it were there
Right.
every day, if we're choosing not to enforce, that would be a clear example where we would have a problem then dealing with a neighborhood development where a developer wants to put up a similar sign. So,
Well, let me ask this, and this is me asking the commission a question, because, again, I don't, other than helping with the ordinances, I don't have anything to do with enforcement, obviously, and I don't prosecute them. Is it a concern with respect to resources, Mr. Chairman? Is that the issue, the manpower, the resources to actually go out and write the citations? Is that the bigger key? We just don't have the ability to canvass the city?
I don't know that it's exclusively resources. I mean, I'm speaking for everybody here. We can only react to what we hear from Lynn and from Robin. I mean, I think resources is one of them, but I think to Lynn's point, the other point is that it seems like we're going too far towards trying to help people solve the problem. I mean, the problem I guess I have is that we've got people that are living in the city that want to follow the rules, and they're the ones that are being penalized by allowing the people that are not following the rules to continue to do that. And, not to be punitive, I mean, we're not trying to punish people, but we want people to follow the rules. And if personally, I think giving people a reasonable amount of time to correct a situation is absolutely what we should do. But when they don't correct it within that reasonable amount of time, we shouldn't go back and give them a second and a third and a fourth chance. We should bring the hammer down, and we need to try and get people to understand that we're serious about the ordinances, or else there's no point in having them.
Well, and listen, I will concur with that. And the only thing worse than having onerous ordinances and having ordinances that aren't enforced.
Right.
And I understand.
I mean, most people don't need enforcement because they're going to comply because that's the kind of people we have in the city, and they want to do that. But and I'm not saying that anybody here is malicious. People get in situations, get cast into situations where they're going to follow the law. The law says that if they're violating, they're going to do X. And if it's easier, to your point earlier, Ken, if it's easier to treat that as a business expense, then unfortunately the ordinance allows that to happen. So in some twisted way, they are in fact complying with the law by paying that fine and continuing to operate out of compliance because there's nothing that causes them to do something different.
And to that that point, in the jurisdictions where I do handle the code enforcement prosecutions, one very effective way of ensuring compliance is when you go to the courtroom. And if that individual is found guilty, when you go up for sentencing, you ask the judge that you'd like to have that individual back in 30 days and offer up evidence of compliance. Because the fine is only to pay for the penalty that's already occurred. We still have the issue of remediation to come into compliance that is outstanding, and the court, under the penalty of contempt, is able to compel that. In fact, many times we'll ask the citizen, how long will it take you to get the shed out of the buffer or to get the fire pit that was non-permitted taken down? I mean, it sounds silly, but these are real issues, and a lot of people live in places like Milton because they know that the government will protect from unsightly, unseemly land uses next to them. So when you get those questions, the judge can ask, how long will it take you? And they say, well, it'll take me 60 days. Fine, this case is reset for 60 days. And at 60 days, I would like to have you back as well as the code enforcement officer and a report that remediation has been complete. Happens. This is nothing new, folks. This happens all the time in other jurisdictions.
Curtis.
Well, to that last point, that's a good lead into question. Actually, I've got a couple of questions, but I don't understand why we can't craft something that probably makes sense given all the constraints we have, one of which I'm not sure it got enough traction, but I think resources is a real issue for us. I know from just one of these little examples that I was involved in or was close by where I live, and so I got a chance to look at the process up close. It's hard enough for them to get out there once every couple of weeks, let alone every day, and then you want to start with a warning. Our objective clearly is to incent the right behavior is not the right word, but we want the rules followed not because we're rule followers, but because they have an effect that we're looking for. So that's the objective, not to punish anyone or to. So if that's our objective, and there are several ways to get their attention, we want the pain to escalate to the point where it eventually produces a response, and that may be different levels for different people, right? If it's a private homeowner, it might be one. If it's a big developer, it might be another. But I don't understand why we can't craft something that probably is going to make sense for the judge, that also satisfies our let's elicit a response and allows minimum of resources so that it can be practical. I mean, I'm fine, sit down with the judge, but like you just ended your comment with, this has been done a million times. There's got to be a solution for all those things.
To your point, first of all, the only reason I'm recommending that perhaps we do sit down with the representatives of the court is simply to make sure that we're not going down a path that they are going to be either grossly offended by or have no interest in implementing, because at the end of the day, all of these citations wind up in front of them.
Well, point taken, and my point was only, it seems to me with your experience and the intelligence of, sorry, just kidding, trying to be nice, of an experience of staff, dealing with the practical side of it, that we could come up with something that probably makes sense, satisfies all the objectives, and then sit down with the judge and say, here's what we're trying to accomplish. We want to minimize irritation and caseload, or whatever they care about. What would be acceptable. That's all I was saying. We ought to be able to craft up in concept at least.
I don't disagree with that.
I think you guys are, it sounds like you're saying the same thing. You're really talking about constructing more of a framework to go to them with,
exactly.
rather than the text.
Exactly.
And then get their eye on before we...
Or rather than nothing.
Right.
And really that's what I was getting at. Then my next question was, what are the, what I saw, and of course I focus on my own little world, so forgive me for that, but what I saw had to do with, I think, more a condition of the economy. It was a semi-abandoned property large acreage property, and maybe that doesn't matter, but, that's kind of an evolutionary or a cyclical deal. Those things didn't exist 5 years ago, and they may not exist 5 years from now. So I suspect as we mature as a city and the economy evolves and so on, the nature of the problems will change. What are the top, 5 things in an equilibrium situation that we'd be looking at here?
You mean in terms of specific violations?
Types of violations, because I'm thinking of the rental property where they couldn't have cared less that we were offering them warnings or issuing cites. I mean, they couldn't have cared less, and that's not typical for Milton. So I'm just curious because
I suspect parking RVs is not
Art-
one of those top.
I was
You
going to
take
say,
the
yes,
top
it
two.
was. Definitely. I was going to use that as an example.
Actually-
That I can assure you, with a fine, that had been taken care of months
Yeah, but
ahead.
to Curtis's question, that's not one of the top 3
Oh, I
violations that
understand.
we see, right?
I picked up
The
on
top
that.
2 are clearly abandoned properties. One, abandoned and vacant now.
Yeah.
That's what we're also saying, just vacant.
Yeah.
Totally disappeared. And then the second would be sign violations of all sorts, and that's something that policy.
do the folks, do the sign violators, let's call them that because it's not, I'm sorry, do the sign violators not care? Are they unable to fix it quickly?
Some of them, a lot of them, it's the cost of doing business.
Yeah,
Particularly.
Is that right?
Yeah, the stick in the ground temporary signs.
yeah.
Cheap.
Yeah, if someone picks it up and throws it away, what do
Yeah.
they care?
They just get more.
Yeah.
With respect to, and this is more of a question with respect to the abandoned properties, what is the concern? Is it just the condition of the property, pooling of water, mosquito, that sort of thing?
It's
abandoned
property
trash?
maintenance, primarily
Leaving
weeds, high
boats.
grass. Sorry?
Leaving boats.
Yeah.
If you don't know by now, we all have our
Everybody does. Can you pick up on that, Ken? Yeah.
Well, it turns out that there's a disturbingly
Categories.
Here they are.
Yeah, right.
Fred has his RV, I have SS Minnow, Curtis has,
there's a disturbingly high
Yeah.
correlation between boat ownership and abandoned properties. We can't.
Oh, it's just flashing light.
Well, I mean, I think Ken makes a good suggestion combined with what Curtis said. I think we probably have enough, I'll use Curtis's word, intelligence amongst ourselves to come up with a framework that we could construct that would kind of reflect what our purpose is, and then be able to sit down with the judges and get their input on that.
And before we end, I mean, and again, I don't want to act like I've not heard what you said, but is it fair to say that the objective as we begin, and Lynn and Robin and I, obviously with your assistance, will bring it back to you to begin putting this framework together, is the main concern is, I mean, just to say it out loud, is to make the penalties more meaningful to induce and incentivize compliance.
Correct.
Yes.
Or you say, you know what, you can accomplish that without penalties, and I think we'd be delighted to hear that. We kind of tumbled to the conclusion that it's penalties that gets it done
monetary fines.
when someone resists. It's not about penalties, obviously. We just think that's the incentive or the disincentive.
I mean, I personally would be more than happy to have something that escalates those penalties to a point, but says, geez, if you fix it, we'll waive that
Yeah.
stuff.
Maybe to the extent,
Well, the
I might look
prosecutor
at
already
covering
has it.
cost.
Well, the prosecutor and judge has that ability all the time, so I mean, you don't have to.
Yeah, but I'm saying
put
build
in
it
your
build it
zoning.
into the equation, right? So you fix it in 30 days, that
Yeah.
fine goes away, you know?
Right. I mean, and
The fine's not the objective.
Understood.
Okay. Any other questions, comments? So how do we move this forward? What's the next step? Lynn, go ahead.
I was thinking if you all could craft your purpose, or we could do it if you prefer, and then vet that through you, then we could start to sit down with Ken and the chair, if it's the pleases the commission, to try to sit down with the judges and get on the same page, try to schedule an appointment.
Why don't we try and craft something and give it to you
Okay.
guys. I mean,
That's fine.
I think we can do that as a purpose. Sure.
Okay.
Okay. Want to move on to the next item, Robin, please?
Yes, the next item.
Mr. Chairman, just a point, do you need me here for the remainder of the meeting? I'll be happy to stay.
I would appreciate if you could stay just for a few minutes, because let's wait till Robin sounds this one, and then we can kind of talk about it, because I have a question I think I'd like you to address, if you would.
The next item is discussion of RZ 1006 and RZ 10-08, amending section 64-1820 and 64-1 for the landscaping business use permit and definition, as requested by the mayor and city council at their December 20th, 2010 meeting.
Okay. For those of us that were at the December 20th meeting, and I think in the packet is a list of questions that Lynn and Robin put together that was kind of a summary of the questions that were raised by council during that meeting. One of the things that was a little confusing in that meeting, in my opinion, was that we once again had a number of documents that council was being asked to look at. One was the original proposal that we had made. One was a red line that Ken had prepared for them, and the third was a red line of Ken's red line that staff had prepared. And I think absent me, because Robin sent them to me in advance, I'm not sure anybody besides council even knew what the three documents looked like. One of the things that I was concerned about during that meeting, Ken, and I guess what I wanted you to speak to, if you would, was that I felt like council somehow misunderstood or drifted off from the whole point of the discussion. I mean, a lot of the feedback from the citizens that were there, a lot of the feedback from council, almost started from a point of saying, why are we putting this into the ordinance as opposed to understanding that it's already there?
I heard those same comments.
Okay. And so what I would like you to do, if you could, is just kind of clarify for us and for the members of the public that are here, kind of what the starting point on this is, so that as we're looking at this, we've got it in the right context.
George,
Yeah.
before we continue,
Sure.
and now that we've actually entered this discussion,
Sure.
is it appropriate to go to public comment first before
Well,
we engage in this conversation? Or
I was
or
going
the
to
public
try.
may benefit from this?
I was trying to really get the thing grounded before we open it for public comment, unless, Ken, you feel like that's inappropriate.
No, I think I can make some preliminary remarks, and then the citizens can input based upon my remarks or not on my remarks.
Okay.
It's certainly up to them. No, and actually, it's funny I got that question, because Lynn and I were discussing that before the meeting this evening. Yet this language, most of this language is already in the code, obviously, and this was an attempt, I believe, quite frankly, in light of experience, is my understanding, that some of this is experience-based, that the city has been having issues with landscape businesses, and basically, quite frankly, wanted to put a little more meat on the bones of the ordinances and the regulations that apply to those, and that's what I understood the purpose of this was, to maybe set forth with a little more clarity what exactly can and cannot be done within the rubric of landscape businesses. So you're right, Mr. Chairman, at the council meeting, I thought that the conversation did in fact go to the notion of why are we changing at all, and I almost got the feeling like this was an altogether new section that was about to be inputted into the zoning ordinance, which is in fact not the case. So point made.
Okay. Appreciate that.
I just had a comment in terms of what I heard that night and what our intent was, and I think maybe what's kind of gotten us where we are now. We know that we have a variety of landscape businesses operating in the city of Milton with the appropriate permitting and with the appropriate intent by the historical definition of landscape business. We also know that we've had some tougher ones come before us that maybe are a little more liberal interpretation of that has caused us to have reason to think about this at all. We've got a couple that are still out there that are operating that, in my mind, are in violation no matter what measure is taken today of the letter of it's in our code. So I think with good intent, we embarked on rewriting it. Or writing it, to your point, Ken, with a little more meat on the bones. One of the things that sort of a light bulb went on for me was by taking out some of the pure agricultural retail component of this and referring to it more as an off-premises operation. There's an element that we removed from the code that made it, in my mind, much more commercial, maybe than we intended, but not necessarily as an outcome that I'm going to be in opposition to. And I think we have to maybe take stock of, is that what we intended? If so, great. And if not, have we maybe done ourselves a disservice by taking that agricultural component out of it that would be permitted under AG1 with the appropriate permits if they're a grower, if they have a small retail component. Well, we've taken some of that out in the more recent language, which in my mind would more succinctly imply a different level of intensity, probably a different size of business, and something likely to be interpreted as more pure commercial.
Understood.
Okay. All right, if there aren't any other burning questions, let's open it for public comment. Is there anyone here that would like to speak in favor of what we're trying to do here? Is there anybody that submitted a card, Robin?
Nobody's given it to me yet, but.
They're still debating whether they want to speak or not.
And this isn't like
I
a
know,
true
I know,
public hearing.
I
so,
know. I'm just joking.
I'm a terrible public speaker, but I am sort of passionate about this issue, and I don't have anything prepared again, so forgive me, but
You need to read your name and
name
address.
and address. Okay, Diane Maloney, 14430 Wood Road. The whole landscaping thing, yeah, it's opened a big can of worms, and basically my feeling is that if it's a business, it should be on C1, and whatever you all need to do to ensure that, because like you guys were making the point earlier, I am very concerned about precedent being set, and where do you draw the line with this whole landscaping thing? And the other, part of that is, I know other cities, Roswell and Alpharetta, do not allow landscape businesses within their residential areas. They have to be on C1, so why in the world would Milton want to be different in that respect? And financially, I don't know how all the permits and taxes, but it just seems like Milton would be better served having these businesses on C1. And there is an appropriate place and time for everything. And because we are so new, we really need to set ourselves up from the get-go. These businesses really need to be on C1. It's just not appropriate to have them in residential areas. And, you were saying earlier, everybody's got their own little personal agenda, and I live on a gravel road, and there was some definition that they were trying to come up with, the road, and it's not appropriate to have business trucks going up and down gravel roads. We have enough trouble maintaining them to begin with, so you need to think about that as well. And again, this whole enforcement thing, if you have them in the C1 zoned areas to begin with, it's certainly going to make the enforcement a lot easier. So, thank you for listening.
Amy?
I'm sorry, I wasn't really prepared, but I'll read you what I read before, and it's actually
You don't have to speak.
apropos. Well, for those of you who weren't there, I had come before to ask you.
You still have to do name and address. Sorry.
Can you hear?
You have to do name and address.
Oh, Amy Peters, 14475 Wood Road, Milton. At City Council meeting, I had come to ask them to talk about some of the standards that had been proposed in the ordinance as written. The hours of operation, the number of trucks, the size of the trucks, the number of trucks and worker trips. But at the end of the day, really, what I'm here to ask you is the same as Diane said, is to ask you to restrict these intensive commercial businesses to commercial zones. Landscape businesses provide a valuable service for our citizens, but due to the commercial nature of the business and the related equipment, I feel strongly that you consider properly citing these businesses in commercial zones. I believe that Alpharetta and Roswell require these businesses to locate in commercial zones, and I ask that you provide our citizens with, at a minimum, the same protections as our neighboring cities. These businesses present unique challenges in enforcement, whether it's the number of trucks on site, how do we count them, whether it's the additional traffic generated by the trucks and personal gain, how do we count them, when can we count them, how often do you have to go out there to count them, the noise from the dumpsters, the heavy equipment that's stored on the premises, the bulldozers, the trucks, etc., the equipment stored on the premises and trailered to customer locations. It's difficult at best to enforce those ordinances. These businesses are thus properly cited in commercial zones where their intense uses will blend with those surrounding uses, not stand in stark contrast, where Milton neighbors will applaud the growth that sound business and respect for the community will generate. Thank you.
Anyone else? Okay. I would like a motion that public comment be closed.
So moved.
Second.
Any discussion? All those in favor?
Aye.
Opposed? Unanimous. Okay. Questions for, does everybody have a copy, by the way? There were 11 questions that were raised by council. Maybe a good place to start would be with number 1, because that would be a good place to start with staff's input in terms of comparing to other neighboring jurisdictions.
Can I make a comment before we do that?
Sure.
Just a funny thing that struck me a minute ago, and may or may not have merit to the discussion, but just an observation. We have been chasing the landscape business thing for longer than I care to remember.
It's our hobby.
Yeah. And we've called upon our citizens to come out on, and they have shown up on almost every single occasion that we've had a discussion about it. And we have never, ever had a landscape business stand in front of us to speak in support of a requirement to stay in AG1 or in opposition to be moved to somewhere else. I just find that interesting that they haven't taken any interest in the outcome of this. So if we're choosing to make a measure that it's going to be moved to somewhere else, they haven't come and given us any compelling reason, large, medium, or small, as to why it should stay the way it is or why it should be.
Well, would this impact any existing landscape business?
No, it shouldn't, because they should be
Well, they'll be
grandfathered.
grandfathered, but yes.
Well, why would they come out and speak about it then?
Only if they
I
plan
mean,
to
like I
make
said,
changes.
new ones, but I mean,
Yeah.
I'm not sure any of the new ones even know that we're making these.
Well, if you're a business that's targeting this area and doing your due diligence about where
Yeah.
you want to be, you'd think
Well,
they
but
would be coming to.
my belief, and correct me if I'm wrong, but my belief is that there is a population of businesses that are operating out there that do not today fit the definition of landscape business as it's defined today. They're not going to be grandfathered as landscape business because they don't fit the definition that's out there. If this is passed as a new ordinance, they will be required to come forward and apply for and get approval for a permit to operate as a landscape business, because this will now apply to them, whereas it doesn't apply to them now. Curtis.
One quick question. I'm going to have a question for Ms. Maloney and Ms. Peters, and not many folks can withstand the long-winded diatribe we usually go through. Are y'all going to be here for a little while, or? No, I mean I'm going to have specific questions, probably more appropriate after we get along with the dialogue Commissioner Ragsdale was talking about. But if you're about to get up, I didn't want to miss that opportunity. Well, thank you very much. That makes you and my mother that No, I have a specific question that isn't appropriate for right now. If you're about to leave, okay, that's, thank you very much.
You may be sorry.
Okay, so these are the items that we put together based on the discussion at the council. The first one is that they addressed was comparison to other neighboring jurisdictions and how they handle landscaping businesses. And we discussed this probably a year and a half ago. I did not give them the information, but obviously we had talked about it, and I have an appended version of it in front of you. I did add Chattahoochee Hills because I felt like that they're very similar and probably even more rural than we are. Well, they are. And to see it, they also adopted what was Fulton County zoning ordinance. I wanted to see if after 3 years if they've amended it, and they haven't. I haven't been able to talk to the planner there to find out if there's been any issues with it. But at this point, they have been continuing to do amendments to their zoning, and they haven't changed that portion of it. So they also, if a landscape business wanted to come in and open a business, they would be under the old, or what are current, the same use permit they have in Chattahoochee Hills. I wanted to look at Lexington, Fayette, Urban County, which is a unigovernment in Kentucky, which obviously they're very equestrian-oriented. So that's another addition to this matrix that was created. And what I thought was interesting was they do allow it, but their agricultural districts, they're minimum 40-acre lots, minimum 10-acre lots, and minimum 5-acre lots. And so for a landscape business probably to go into that wouldn't be economically feasible, but they do have a board of adjustment that would review the requests, and then they would put on conditions to that development. So it's a little different way than how we do it, but they do technically allow a landscape business under certain conditions. So, and again, as the audience had commented about Roswell and Alpharetta, I do want to make the point that Roswell and Alpharetta do not have strict AG1 districts. They have residential districts. They have rural residential, but they don't have true agricultural districts. So therefore, that's why they do not allow it, is because it doesn't exist. Again, Cherokee County does not allow it in AG1, and Forsyth County does not allow it in AG1. So again, that's a question that the council asked, and I was just updating the information a bit. Again, should we consider this use an AG1 use? And I believe that during our discussion at the council, I felt like we communicated to the council that you all had considered that question, and you all did. So I don't know if you want to discuss that any further about the big picture of, do you want this use to continue to be permitted in AG1? And that was the council's question to you.
If the question is whether other folks surrounding us allow it in AG1, I think clearly that, the majority of them don't.
Well, I took their question that night as posed back to us in the context of it should be an AG1 or a C1, because I think that at the time that question came up, it was after an interpretation of the words that we had put forward, as it seemed to be more intensely commercial to them. So they were then saying, why would we still consider this to be an AG1 business? Mm-hmm. So if you ask the question that way, it's a simple answer for me.
Well, I think, and again, this goes back to, I guess I was trying to get Ken to address, is they didn't take note, in my opinion, of the fact that it's already there. I mean, this is not something we're proposing to put into AG1. It's already there. The second thing is, I felt like what they were doing was looking at it. They seemed very hung up on making sure that it was a check-the-box kind of a thing, where if it didn't fit within the box, it couldn't be there, and very concerned about not allowing discretion to play into where these things should be located. I mean, all of our discussion, I think, when we talked about this, was saying we want to create this in a way that if somebody comes in with an application and it looks like it's an appropriate use for that location, that we should allow that to happen in AG1, and if it's not appropriate in that location, because it's all residential around there, or whatever it might be, that we would have the ability to say, no, that's not appropriate in that location. If you take all that discretion away so that it's got to be X number of square feet, and it's got to be this, and it's got to be that, nobody needs to make a decision anymore. I mean, it's either in or it's out, and it's black and white, and to me, that whole discussion just never got before the council. They seem more concerned about not allowing discretion, whereas our whole thrust was towards allowing that discretion.
Yeah, I mean, the second sentence, that was, we went over that ad nauseum.
Right.
Make sure that it was, like you said, that discretion could be used there.
I mean, the flip side of that is I think about the areas that at least the ones I'm familiar with, that are Zone C1. I don't see a landscape business being appropriate in those locations.
I'm sorry, say that again, George.
If I think about the areas of Milton that are Zone C1, to me, a landscape business, at least of the type that we have seen come before us, doesn't fit there.
Right.
It doesn't feel like it fits. You're going to put a landscape business
Here.
at Birmingham Crossroads within the Four Corners? It doesn't seem like it fits there, to me.
Yeah, it's more associated with the agricultural side than
Right.
anything else.
Commercial side.
To your point, George, and Chris, to your point about the second sentence, they never got there.
Really?
The mayor and council never got
No.
to that. And for those of us who were there, I would say the takeaway for me, and George is keeping what you just said, is that they were looking for a more black and white interpretation. They weren't looking to have to make a decision as a council.
Right.
They wanted it to be this square peg fits in this square hole.
And I don't know, Ken, this is something else you may want to comment on. I mean, I sensed a real fear of them. To me, that isn't spot zoning when they're looking at each application within the context in which it's presented, and whether the use and the scope and the intensity is compatible with what surrounds that. That doesn't make it a spot zoning issue.
No, that's right. I mean, that's the whole function of applying the discretion to the application, is so that you avoid spot zoning and can deny a permit to a land use that makes absolutely no sense in that location. That's the point.
A lot of their discussion, if I'm remembering correctly, went down the path of some sizes of business that were much larger than we had contemplated, I think, in the usual interpretation of things we've had before us before. We talked about a significant number of trucks, the ability to screen them or not screen them, the number of vehicles on the property during the course of the day that were there by the workers, the ability to screen them, or the requirement to screen them or not to screen them. If we listen to the issues that I'm very sensitive to by Mrs. Maloney and Mrs. Peters, they do have sizable trucks going up and down their dirt road. That is, a larger estate lot, but nonetheless, they're very visible as they're intending to enjoy life on larger parcels, but they're still subjected to a more significant commercial or industrial type of business with large trucks that come and go. I think if I think about the conversation that was had that night versus the conversations that we've had, it's like train tracks. We were running on parallel tracks, and they never crossed.
But maybe in opposite direction.
Yeah. So I don't know that really one will necessarily benefit from the other tonight, because we didn't find any crossroads, or not as many crossroads as I thought we were going to find from their conversation, which is why I chose them to come that night and stay for the duration of the conversation. But
well, why don't we, for the sake of trying to move this forward, why don't we let Robin walk us through the rest of these questions and come back to number 2 at the end? Because I think the others are a little bit more, answerable, if you will.
Okay, the next question was, did the recommended definition expand? That was their question. And yes, I think it was expanded, but
I don't think it was expanded. I
We
think it
added
was
more
clarified.
words.
We
We
had more words.
expanded in the sense of describing it more succinctly than what was there prior.
Definitely.
Just clarify. more
Right.
things.
So, I mean, I guess we can say it's not that we're allowing more types of uses or whatever.
As a
it's
matter of
just-
fact, if anything, I think what we've hopefully done is caused more of those uses out there that were kind of in the cracks, if you will, to come forward and have to comply with something that right now they don't have to.
Okay. Whether we should be more specific on development standards or leave some room for interpretation to individual proposals by the council.
I think we're pretty unanimous on that, right?
Yeah.
We'll try to make that point again.
Well, they just didn't get it. But I don't, and we weren't there.
That just wasn't what they were looking to find.
Yeah.
Okay. The next item is clarify how to limit storage of materials, specifically height and enclosure, including an overhead cover, for instance, of materials. There was a lot of discussion on.
Well, and they specifically pointed at number 10, where we said that everything has to be contained in appropriate size containers and no refuse or debris shall be stored in the ground. They questioned for storage containers whether there should be a maximum height, whether they should be covered.
Same thing with trucks and equipment.
Right.
Where it should be garaged or
Mhm.
screened.
Right.
And that's one of those areas where you can allow them to have discretion,
Mhm.
depending on the size and type of business, or
Yeah,
No.
because
Or
if
the
they have to
parcel
come
land.
forward to get a permit, then all of that can be
Addressed.
detailed and addressed by the council from the plan.
Go ahead, Rob.
Okay. Define or reference a more specific identification of access roads, maybe an adopted map or listing of specific roadways. And Lynn and I spoke about that, and I think I forgot to get a map from Carter for something more specific, because you had asked to address, we need to define exactly what is what.
Well, this keeps coming up over and over. I mean, it's not just here. We keep using terms that don't have any definition behind them or any context behind them. So when we talk about arterial streets, nobody really knows what that means, or collector streets. So either creating a definition or having a map that depicts that will be a big help, I think, for a lot of different things.
And just to clarify, too, that we did have a request for landscape business on a gravel road, and it was automatically denied because none of these classifications is a gravel road, and there was all this discussion about gravel roads. Like, well, that's a non-issue.
Right.
I would tell you, there was a person who attended that night who lived on either Birmingham Road or Freemanville Road, I don't remember which. And they engaged me after the meeting and said, so, does that mean you're driving everything to one of those two roads? And I said, no, but to George's point, without a better definition of what access roads are, that was the community, that was that individual's interpretation from the community that, gee, I live on this road. We have citizens who call them open road neighborhoods.
Right.
And,
Right.
that person would probably find that offensive if we're saying this kind of business is then going to be forced on to what they interpret as their neighborhood road too. So that's a tough one until we get to a better definition of the road part.
Okay, limit types of equipment, i.e. commercial dumpsters. A dumpster's a dumpster, but it isn't necessarily defined that it's commercial, but that was their concern.
Yeah, one of the comments that was made was that we weren't specific in terms of the type of equipment or the size of equipment that could be stored.
Right.
We did say that it needed to be garaged or screened, which to me certainly starts to impose some size limitations on things. But we weren't specific, and that was a concern. Do we want to be any more specific with respect to types and or sizes?
You could probably go on forever trying to
Yeah.
define it.
But I think it goes back up again to
Discretion.
discretion.
Yeah, the discretion
I mean, we
part's
said if
critical.
it's determined that the property can accommodate such vehicles and that storage of such vehicles.
Think about the last landscape business that was in front of us. And if we had deemed it only appropriate to have a 40-foot dumpster, that guy couldn't comply.
Right.
Because his space could not accommodate a 40-foot dumpster.
Exactly.
Right.
But it probably could accommodate a 10-foot dumpster.
Right,
So we wrote in discretion there on purpose.
right. Okay,
Okay. Screening versus buffering of parking and storage areas, particularly accounting for topographic changes. And again, I know we've had discussions about this.
I guess it's particularly the view from the hill.
Yeah, I don't
Yeah.
think we can protect from the airplane going over and like the view of
Well,
landscape.
all these, again, come back
Come
to
back.
site-specific,
Same thing.
decisions that have to be made. Now, the one that may not fit that is number 9, hours of operation consistent with the noise ordinance. I don't remember what the
Nope.
noise ordinance says.
Well, I gave you a
Pass it
copy of the noise ordinance.
Yeah, I know you
It's,
did.
red, it's kind of multicolored. And I believe that down
7:30
in
to
section
7:30.
2702, toward the bottom of the page.
Yeah.
Sounds originating from construction sites under permit as a result of construction activity or commercial lawn maintenance are exempt from provisions of this article, but only during the hours of 7:30 a.m. to 7:30 p.m. on weekdays and 9 a.m. to 6 p.m. And I think our intent was if the office worker wants to get there at 6 in the morning, why can't she go to her office at 6 in the morning? I think that was you all's intent.
And we
But the
limited,
fact
we
is
limited
they'll load
the,
up equipment before sunup. I mean,
Sorry?
The fact is, they typically will load up all their equipment before sunup and be gone, off-site, almost before 7:30 in most cases. That's just the type of that business.
But we talk about our own personal pet peeves. I mean, I live on the edge of a golf course. They don't mow until 7:30, but there are days at 6:30 that they're staging, so they're in position on the golf course to be able to crank up the mowing part of that. It's offensive at 6:30 in the morning. It's offensive at 7 o'clock in the morning. Some days it's offensive at 7:30 in the morning. I think we might want to rethink that part to make sure that we are maybe holding tighter to the hours of operation part, just so that we don't provide a little bit of flexibility that it wasn't intended, but that could be taken advantage of.
Plus, we don't want conflicting ordinances either.
No.
If they can operate, but they can't make any sound, then
Yeah.
Well, Robin, the part that you reprinted for us here is the exemptions. What does 20-681 say?
I'll have to get the code, I don't have the rest of
Here,
Yeah, he's got it.
Fred's got it here, Rob.
it. Okay, but that's the city code, not the.
Oh, that's the zoning code, isn't it, the city?
Yeah, it's divided by residential, commercial, industrial, and there's a decibel level.
By
limit
use or
certain
by zone?
hours. I'm
By
sorry.
use or by zone?
I believe it's by use. Robin, if you'll double check that for me. But I believe it's by use, not by zone. The
Allowable decibel.
the
level.
table with the allowable decibel level. It's use. That's what I was thinking.
Because what we're talking about, at least in my reading here, what we're talking about, it doesn't fall under one of these exemptions.
Yeah, the closest would be the lawn maintenance.
Yeah, but that's the
Exemption,
activity
but it's
of,
really-
that's not staging vehicles and
Yeah, it's once they
moving
get there
trucks.
typically.
I'm sorry?
Once they get with their trucks to
Right.
your house.
Right. Robin, to your point, maybe, or, sorry, Lynn, it may be appropriate to differentiate between the hours of operation from the office and employee vehicles versus vehicles used in the operation of the business.
Okay. I think that's what we were trying to do with the two different times.
Yeah, the serial deliveries and then the hours of operation.
Yeah, the first one covers the idea of incoming, right?
Yeah.
But it doesn't cover the outgoing.
Mm-hmm.
So maybe put it in there.
Yeah, because that would bring it within this 7:30 to 7:30 idea.
Or you just put, consistent with the noise ordinance. Just leave it
That's a
alone.
cop-out, come on.
Just like the overlay district one.
Yeah, yeah.
Keep referencing other sections, so you have to keep going back and forth all over.
Yeah.
It's divided by residential and commercial, and it's measured by the DBAs, and then
It's measured at the property line or anywhere within the receiving property.
But what are the hour restrictions?
Maximum, the hours are between the hours of 10 p.m. and 7:30 a.m. The noise level shall be reduced by 5 dBA at the receiving hour, or the receiving property. Between 7:30 a.m. and 10 p.m., the applicable noise levels may be exceeded for any receiving property by no more than so many dBA for 15 minutes, 5 minutes. There's some other little caveats there.
So the noise level in this case would be measured on a nearby residential property as a receiver, and whatever that decibel level is, if it exceeds that by, what'd you say, 10?
Right. Well, again.
But the hours is 7:30 a.m. to 10 p.m.?
Till 10 p.m.
Okay. What do you guys think? I mean, I think Robin's right. The intent, I think the intent we had with number 7 on our proposal was that the truck traffic would be between 7:30 a.m. and 7 p.m. and that but they could operate the business with employees and offices and everything else from 7 to 9.
And that was to allow for daylight savings time in the summer.
Right.
Returning back to the shop.
Right.
Have one thought. I'm not even sure that it's relevant, but it wedges this a little bit in my mind. But from a pure agricultural perspective, and I worked on a family farm summers while I was in school, so I got a fair dose of that. But we worked the hours of operation, as my grandfather used to say, was caint till caint. Which means you start when you can't see and you stop when you can't see. And literally, we'd be out on a tractor at sunup and wouldn't quit until we couldn't see anymore. And that's pure agricultural use. This is not. I mean, we're talking about business restriction here and trying to minimize impact. But if this was an agricultural function, I'd have a little different perspective on it. But the wedge part of this is that it sort of underscores that we're not talking about an agricultural function. I would want to minimize the hour window, but I'm sort of...
Well, I guess there's two questions. Is the hour window that we've specified too broad, or is it the fact that we haven't properly captured the vehicles associated with the business going and coming? Or both?
I thought we had done a pretty good job of it originally, but
Well, we didn't specifically capture the vehicles. I mean, to me, the vehicles are in number 8, which says they can be 7 a.m. to 9 p.m.
I guess you could add with the vendor materials that the congregating of whatever, the equipment and staging would be between 7:30 and 7, if you want to change that, amend it. I mean, we could include the staging and all that in number 7.
Yeah, but I would still think it needs to be consistent with the sound ordinance. I mean, if they're not making any noise, I mean, at least not so much noise that they're bothering the neighbors, why should they have to wait till 7:30?
I would think that the noise that they would make would primarily be loading their equipment and their materials. Some of that's not going to be much, and then some of it, bobcats, and
Right.
loaders and skidders.
But again, that's going to be site-specific too, right? I mean, it's like the tree falling in the forest if there's nobody there, right? If it's a remote location, the ordinance is written the way it is because if it's not offensive to anybody, it shouldn't be a penalty to somebody. If the adjacent properties aren't seeing a higher decibel level than the ordinance allows, we shouldn't be restricting what they're doing, right? I mean, I like
think
Chris's
so.
idea, just to, without being snide about it, just to tie it to the noise ordinance. And maybe flip it around and say, leave the vendor material delivery thing the way it is, but say limit, add something specific to say that all operations have to comply with the noise ordinance regardless of the,
Well, you got 11 down here. The proposed use shall not create noise, odors, or produce light spillage that's considered a
Right,
nuisance
yeah.
under Georgia law. So you could just,
right,
I mean, that covers it.
right.
Well, we still enforce the noise ordinance, so even if you didn't put it in the use permit, it's still something that they have to comply with.
Right.
So, I mean, it's again, it's already there.
Inferred, yeah.
So where do we go? We okay with it the way it is?
I am.
Curtis?
You mean okay with the way it is, assuming
way
that
we
the noise
proposed it.
ordinance
Yeah, applies.
is a cloak?
Yes.
Yeah.
Okay. Yep. All right.
Okay?
And I think there was a traffic aspect to that, but not a significant one.
Okay, if we're done with that, then,
There was a question of the number of commercial vehicles and whether they should be specifically garaged or screened. I think
Right.
we left the option for being garaged or screened. And again, we didn't limit the number of vehicles because it's dependent on the size and intensity of the business, right?
Well, we did put a maximum on it.
We put a maximum on the building size. I don't think we put a maximum on the number of vehicles.
Yeah, number 6, maximum of 6 employee vehicles.
Oh,
But
yeah,
not
yeah.
business.
You're
Well,
right.
you're right,
You're right.
not vehicles in use of the, or used by
Right.
the business, I
Right.
guess.
Of course, the extent of that is if they're all garaged, then you've effectively limited the number of vehicles.
Right,
Yeah, to the 5,000 square feet.
right.
All right?
okay, so you're okay with that?
Yep. Number 11.
Consider whether the definition allows for or even requires that the business owner reside on the property.
We never even talked about that.
Yeah,
I'm not sure why that's even something we should be talking about.
no.
I will say that a lot of
What's-
the, and there's no way that the council would have known this, but a lot of this material that came from Danbury, Connecticut, I went back to the original material, and it did specify in that situation, it was for somebody who lived on the property, but that's never been a discussion that we've had. I think you guys just use the.
Well, we had both.
Right, and then we could. Currently, we don't disallow somebody living on the property. The one on Taylor in Birmingham, the supervisor, or the whatever,
Right.
lived in the little house on the
Yes.
property. So,
But he's not even the owner of the business. He's
Correct.
just renting
He's
the
just-
property or caretaker.
right.
All right. So let's go back to number 2. The $64,000 question.
Well, it goes also back, as we've talked before, about the extensiveness of our AG1.
Right.
Right.
I mean, that's where we were when we finally made the determination is, is there another way other than just say AG1?
What do you mean by that?
Well, we were saying before, I think, when we started, is that, landscaping, agriculture, all that fit together. Then we said, well, but is it commercial? And then we got back to saying, well, and it's come up before in something else, that AG1 is so broad that it doesn't give us maybe commercial within AG1, I guess, maybe. That's what I'm saying.
Well, I would argue that with what we're doing here, that we are, if we don't go back to some of the discussion I walked away from, my interpretation of some of the discussion the other night was, if we came back saying, we'd like to reconsider what we did, and we think this is an appropriate C1 use, that the mayor and council would not find that an offensive change to our plan. Now, if we don't do that, I would suggest, Fred, to your point, that by putting these restrictions on the way we are, we're offering a chance for a limited commercial business within AG1. It's a commercial business with limitations, not to exceed X, Y, and Z by these definitions that we have just worked through again.
Okay. I would agree. I thought
So,
you were saying it was
We kind
either
of have
or.
to figure out where we want to go.
Exactly.
Well, let me ask a question. I don't want to get too down to the weeds here, but if I don't think of a good example. Let's just say that I am a widget salesman, whatever that is, and I decide that I'm going to keep all those widgets in the basement of my house. But I'm not going to sell anything from there. All I'm going to do every morning is load them in my car, and I'm going to go somewhere off my property. I'm going to sell those widgets. Do I have a commercial business in my home? I'm sorry? That's not my question. Do I have a commercial business in my home?
I'd say yes.
I would say no. There's no commercial transaction taking
Yeah,
place in
exactly.
my location.
You got manufacturing possibly in your home, but
No, I'm just storing stuff. I'm
Storage.
not making anything. I'm just storing it in my basement, and I
You've
load it
made
up
the
every
case
morning,
now
and
for
I go
every
out and
Mary
sell
Kay
it.
saleswoman
Yeah.
in America.
Exactly.
Yeah.
Yeah, exactly.
I don't think I want to be a Mary Kay saleswoman,
No.
but
I'm just saying.
I guess what to
no, I
me,
see what-
that's what this is, right? There's no transactions taking place on this property, right? They're storing their vehicles, they're storing their materials, but all the transactions are taking place somewhere else. There's no services being dispensed here, right? Even if there's an office here, the invoices that are being generated out of those offices are for services that are taking place somewhere off the property. To me, and I'm not trying to fight for one or the other, but I think, to me, although it is more of a commercial business than maybe a nursery, right?
Right.
We haven't eliminated the possibility of a nursery. All we've done is we've carved out the nursery and said, here's a nursery and here's a landscape business, and they're different. We haven't taken that away. Curtis, sorry.
Had my arm stretched out as far as it goes.
Sorry.
It's only
Chris was leaning forward. I guess.
sorry.
8 inches long. So, in my mind, the landscape, non-nursery landscape business is no more agricultural than a house cleaning business or a home construction contracting business or anything else. I mean, and your example of storing widgets, and you could carry that down to Mary Kay or a salesperson that has his wares in his car and he drives home at night and then he goes back out and there's a distinction in my mind between that and staging and composing materials to bundle up and go out and serve, and having employees. I mean, the whole notion of employees, I think,
You're right, that makes a difference.
I don't think it's only an agricultural use in that it deals with people's yards. You know, I mean, other than that, it doesn't sell a product necessary, an agricultural product from the property. Because if it, well, we've been through this ad nauseum. You know, the notion of growing and selling what you grow as a farmer versus with nursery type situation versus this.
Well, and one could argue that even equestrian, to me, equestrian farms are very commercial. You have people coming to ride and to, to take care of their horses and
Take lessons.
Take lessons. I mean, there's transactions happening all the time.
But you're probably dealing with a larger parcel in that case than some of the ones we've had before us so far.
Robin McDonald is against horses.
No, I'm just making the point. I'm
we've
sure there's a large amount of money that transacts in some of these farms, and some of them are large, some of them are small, and probably some of them have a lot more.
That's fair enough. By my analogy, it involves animals, but there's a distinction there, and if I thought, I think if you thought about it for a minute, you could probably say, okay, that, do you think that's analogous to a landscaping business?
When it comes to the transaction part, and that you have trips coming every day, I mean, you have people going to ride their horses quite a few times a day, or coming to take care of them, or whatever. I mean, there's traffic that's involved. There's sometimes they have events going on. I mean,
but it's a farm in my mind, and which is agricultural by definition.
There could also be employees going there.
and I'm not saying it's not agriculture. I'm just saying it produces some of the same trips and noise and smells. And
Well, we don't have any big farms here, but in areas where, I've talked about my example before, we had employees, we had people showing up, and it was a working farm. And anyway, what's the point? Is there a point there? I don't want to blow it off.
No, I'm just pointing out that there's commercial transactions going on all over the place, whether it's a nursery or whether it's, a equestrian farm, or whether it's the orchid farmer, or whether it's, whatever. There's commercial going on.
Well, in my mind, forgive me, I don't mean to. My arms are so short you can't tell if I put it up or not, so I can just claim that I did.
Still have four.
That's right. That's right. Is the distinction agricultural or commercial?
It may be neither. It could be a hobby farm, or it could be, a commercial more, geared for the outward, bringing in customers to ride and to have lessons. I'm just throwing that out.
Well, in my mind,
I don't think just because it's not agriculture. I mean, it is kind of related, but it's not to say, well, because everything else that's in agricultural, we don't have to consider it commercial, because I think there are some commercial entities out there that are associated with agricultural uses. I'm just making that point.
Well, yeah, I mean, it seems like the biggest concern is the size of the business. I mean, somebody doesn't want, 20 commercial trucks being loaded up every morning next to their house. But if it was one, which, still falls in here, no one would even know that business was operating next to them probably. And so, I mean, how do you put some sort of cap on how big these are? And I think we've tried to do that as best we can, with leaving it up to the city council with their discretion to deny it if it doesn't fit within the size of the parcel.
Is the landscape business allowed by right in C1 today?
As a special use. You got to have a special use.
You still have to have a use permit.
No,
Oh, in
you
C1,
only need
I'm
it-
sorry, I'm thinking
yeah,
AG1.
No, it's a
C1.
permitted use in C1.
It's a
no.
permitted use,
Yeah.
right? So
Right,
they
right.
don't need a use permit for C1.
Only in AG1 they need a use
Right.
permit.
So that aspect of it's already in place.
And not to get too far afield, but do remember that, as part of what we're going to look at for our priority projects this year is, expansion of some of the AG1 uses by right, so that there can be additional rural and farm-related, specifically farm-related uses. So as we have this discussion, we'll have this discussion over and over and over again.
Right.
If you look at this, if you were to take off landscape business as the title of this, and you put on concrete concrete manufacturing business instead. How many, and if we were to talk about this only in C1?
Pool installation.
Yeah,
Something
okay.
like
There's
that,
okay,
you know.
put pool installation, because you're talking about equipment and trucks and a number of employees. And,
People's yards.
yeah, so if you were to put that on instead, and that's probably a C1 application today, not an AG1 application, how many restrictions are in conflict from the AG1 interpretation for a landscape business versus a C1 operation of a pool construction business? My assessment, or my naive assessment, is there probably aren't too many differences, except for the fact that we're trying to fit a landscape business into, that we're defining as having some commercial aspect that's going to have noise and trucks and equipment and storage and those kinds of things, that we're trying to guard the rights of the property owners, our citizens. We're trying to fit that square peg into a round hole and make it and minimize the impact on the community. So having worked on this for as long as anybody else has, I'm thinking we put forward a pretty good document limiting it. I'm now giving myself reason to rethink that and say, maybe we were on the wrong track. And let's get back to the protection of our rights of our citizens and quit trying to fit a square peg into a round hole. If it's going to be commercial and there's going to be noise emission, there's going to be hours of operation that are in conflict with what is intended to be a peaceful surrounding of our residential AG1 community. It's also not necessarily consistent with that of an operating farm, an operating horse farm, or whatever. I think maybe we call it what it is and say it's a commercial use and take it out of AG1.
Or a grower.
Yeah, a grower is different. I'm just proposing that for discussion. I haven't necessarily come to that final conclusion, but I would tell you that's where I'm leaning at the moment.
I agree.
Joe?
Going back to your point earlier,
Joe's
George,
arm's
about
longer for his side.
Everyone's.
whether there is a C1 area that could accommodate a landscaping business, and I don't think there is, just by the nature of it. So
Not today.
essentially what we're saying is, we're not going to have any more landscaping.
Exactly.
So why
Well,
not cut to the chase and just
Well, that's
say
not
that?
necessarily. If we look at the 2025 master plan, there is probably room in our city of Milton for more C1 property. So we're not saying it's not going to happen forever.
I'm sorry, what was Pikes and GLM and that whole strip along 9?
You mean down in Roswell?
No.
No, North 9.
I mean,
Right past
there was
Bethany.
Ranch, restaurant for the ranch.
I don't know where Pikes was, but you're talking about Green Brothers, I think.
Green Brothers.
Green
Yeah,
Brothers.
I'm sorry.
Well, but
Green
that's all
Brothers.
right. That
Yeah.
other corner, even though it's Alpharetta, was going to be a Pikes, but it was turned down. Alpharetta.
But
turned
they
it down.
weren't retail. I mean, they gravel,
They fit the-
chips. They fit that, and they were. I always thought a reasonable C1. I've been to both of them, and et cetera, et cetera. I don't understand why that wouldn't fit in that kind of a. Maybe it's almost C&I type area, but.
But it feels like we've got one issue we need to deal with. I mean, I think we're all pretty comfortable with the ordinance the way we wrote it and the discretion that we've allowed. The question is, do we want to try and eliminate it in AG1 and restrict it to C1 as a recommendation? I mean, we'd have to go back and do some rewriting to make that work, but if that's where we want to go, we need a motion to either leave it the way it is and go back to council with it the way it is, or recommend that we restrict it to C1. I'm sorry?
You would just pull it all the way. I mean, it would just be dictated by the C1.
Yeah.
Okay.
I mean, we'd come back with it as a C1 ordinance, but,
You wouldn't need one.
You would just delete what you have. Delete the use.
I would argue that a lot of the things that we've talked about in here, if you look at C1, if we want, it's a good point. If we do go to C1 the way it's currently written and we do pull it all together, all the things that we've put in here in terms of the discretion that can be applied to a specific application go out the window as well.
Well, and, yeah, and the restrictions, I mean, you could have a much, much larger
Yeah,
business.
that's my point.
I
That's my
mean,
point.
Yes, but the council would have the discretion to put a condition on there as they would any other rezoning application, so.
Anyway, we need a motion, one way or the other, to either keep it the way it is, or pull it and recommend that it be eliminated from AG1.
For the sake of argument, I'll make a motion. You guys had your hands up
Which
before I
one?
did.
Well, Joe might have had a comment.
Were there any?
You know, as Paul said, we talked about it, and I thought we came up with something that we all considered well and executed well. And I don't know why we're going off in another direction. We spent so much time doing it. We put a lot of thought into it.
I'm willing to admit that I'm questioning.
Tired of it?
No, question my logic coming forward to this point.
I'm
Trying to do the right thing for residents and for potential landscape company service providers. But your square peg in a round hole analogy makes sense.
You know, I mean, I was a willing participant and helped craft this language, just like everybody else at this table, and we've spent, countless hours doing that. Where I've given myself reason to rethink what we've put forward. I mean, there's no question I think what we put forward is good work. For whatever reason, it was not accepted that way by mayor and council. And they offered some good questions to give us reason to rethink what we did. And then, in the course of the discussion that we've had tonight, in my continued sensitivity to what we're hearing from our citizens about their wants and desires, and those that are finding these businesses to be too intense, I think that the square peg and round hole analogy does work here. And for at least for the sake of argument at this point, and having heard the mayor and council sort of redirect it to this sounds to be like a C1 business, I would put forward that my motion is that we consider pulling pulling landscape business from an acceptable AG1 business, and that we propose that it be a C1 use. I'll just leave the motion at that.
I'll second.
For clarity, we probably need to treat each one of these separately, right? So, I mean, we've got RZ 1006, which is 1820, which is what your motion is about right
Yes,
now. We can
that's
deal with
correct.
RZ 1008 in a minute. Okay. All right. There's a motion on the floor. Discussion.
Discussion. If it goes to C1, the others are grandfathered.
Right.
Well, all this work that we wanted them to do, what happens?
What do you mean all the work that we wanted them to do?
If we passed what we have written, they had to come in and get permits and changed and so forth. To
The
me,
only ones that are grandfathered are the ones that have already been approved for a use permit as a landscape business. Those that have
Okay,
not,
so
we
that-
don't
so
know.
we-
don't
so we
affect
don't have-
anybody that's operating.
right,
that.
okay.
And have a
Okay.
current
Which
business
is why,
So it's-
I'm sorry?
And have a current business license.
Yeah, which
Yeah.
is why, when we get to the definition, we need to
Okay. That's it.
seriously consider keeping that.
Just to put a number on that, there's about 6 to 8 that this would really affect.
6 to 8. Okay.
Any
When you
other
say
discussion?
6 to 8, it would affect
Businesses that
that are
in-
operating illegally,
that are in AG1
but have permits?
and are operating legally.
Okay, so they wouldn't be affected.
Right.
Right, they'd be
Unless
grandfathered, yeah.
they were to
Cease.
cease.
Well, actually, wouldn't it stay with the property use permit?
Well, if it had a use, it would stay.
This doesn't preclude, by the way, at least in my opinion, cannot defer to you, but it doesn't preclude somebody who wants to put a landscape business in AG1 coming in and asking for rezoning.
Right.
Mhm.
Effectively it does, but yes.
Makes it a lot harder, let's put it that way. Any other discussion?
Well, just to put a point on that, though, doesn't, and maybe to circle back to our enforcement discussion, doesn't it really incent the kind of agricultural business that we find acceptable as a community? If they want to be a grower or a farmer, open arms. And there are ways to be in the landscape business here if you want to be a grower, but service provider becomes generically just like any other business.
I would much rather have a landscape business next to me than some chicken farm or a horse farm or any.
You're more concerned about odor than noise.
Well, I mean, there's plenty of noises from any
That's true.
agricultural
That's true.
farm like that.
That's true.
And like Curtis said, I mean, they're operating tractors and anything else early morning as soon as the sun comes up. I mean, they've got just as much, if not more, deliveries for feed and everything else that's associated with that. I mean, those are very intense businesses, even though they're agriculture in nature. So,
You live in Milton?
you don't think Seven Gables Farm? I mean,
I'm-
they've got a lot of stuff going on there.
No disagreement there, but I mean, I think that's what it's about.
Yeah.
That's why I'm here.
I don't want to have to.
Any other comments? Let me make one myself. I mean, I personally would go back to the discussion that Robin and Curtis had. Well, I guess I agree with everybody at some level. I feel like we're singling out a particular commercial activity or quasi-commercial activity and taking it out of AG1 and allowing or to continue a number of other equally commercial activities that are not appropriately captured within AG1. So I'm uncomfortable with that. I mean, I think the whole equestrian side of what goes on in Milton with, whether it's stabling horses, whether it's giving lessons, there is commercial activity that's going on that is not being required to get business licenses right now and not being required to get use permits for what they're doing. And I feel like we've kind of singled out landscape businesses by doing this and saying, we're going to take you guys out of here. And as Joe said, at least for right now, effectively eliminate the possibility of anybody having one. So that's just my 2 cents. Curtis?
Two comments. One, Chris, back to your point. I mean, I was being facetious, but from a practical standpoint, and we've had this conversation 50 times if we've had it once, it's too expensive to have a chicken farm here. And it's almost too expensive to have, almost any kind of agricultural operation. But your point, your point's valid. But there are practical restrictions because of the economics. But George, to your point, I mean, no other type of entity has been converging on Milton to set up shop here as a drop ship point for serving the community. Maybe I'm not thinking of the right examples, but what other kinds of businesses have there been, or what were you thinking of in additional landscaping that is an issue?
The equestrian business.
Oh.
That's not the point, Dan. The point is that they are as much a business as this is, and we are not addressing that, in my opinion, in the same way. And that's just my personal opinion. I'm not saying by any means that I want that stuff to go away. That's not what I'm saying. I'm saying that we're taking a business that we are trying very hard to regulate and ensure we are managing, and there's this whole other thing out there that we're not paying any attention to, which to me is very analogous to what this is in terms of the fact that they are conducting a, quote, commercial business within the city.
George Ragsdale is against horses. I had to take Robin up.
Having said that, there any more discussion? There is a motion that's been made and seconded that we withdraw our recommendation to amend 64-1820, and in its, and Paul, I'm paraphrasing because I don't remember exactly what you said, but basically eliminate eliminate a landscape business as a permitted use in AG1.
That's close enough.
All those in favor?
Aye.
I need hands because I can't tell.
Curtis's hand's up.
Wait, he's really cool.
Jennifer's hand's up. Okay, opposed?
Okay, so motion fails.
4-3. Okay. So where do we go? We have the option of leaving status quo, or proceeding with the recommendation that we had made before. Does anyone want to make a motion in that regard, or do we need some more discussion about which way we want to go with this?
Really, what it comes down to is do nothing now, void of, with the failure of that motion, which, to everybody's point, just to remind, for the sake of argument, to now do nothing, or just restate that we want to carry forward the work that we've done with the clarifications for the mayor and council, hopefully with the clarity that they understand that we've built in some of these measures for their interpretation, to allow them the assessment of the intensity, the size, the scope, the scale, all the other words that we carefully crafted into it on purpose.
Well, they can certainly make changes or edits to it themselves, correct?
Yeah, you bet.
So, I mean, this is just a suggestion coming from an advisory board.
Well, this is going to sound very strange coming from me, but I would like to make a motion that what we take forward to City Council is a recommendation that they approve one of two alternatives. One being the ordinance as we presented it before, with the changes that have been proposed by Ken. But in the alternative that but I think part of this is to make sure that we, Paul, to your point, adequately explain our reasoning behind why we have this in front of them. But in the alternative, if they don't feel disposed to accept what we're proposing, that they withdraw the landscape business as a use, as a permitted use in AG1, and restrict it to C1. That staying the status quo is not acceptable, that they should need to do one or the other. That would
Agreed.
Okay. You have a motion in a second.
Any discussion?
The only thing, just to emphasize for staff, I think there has to be some explanation of, as opposed to say, okay, well, which do you want? But the reasoning behind what we did and how we came about to that conclusion.
I think I'll be in a better position too to try to advise the council. I don't sit through these meetings, of course, but now I have, and I've watched the process unfold, and sausage just captures it. But I still, it's been healthy though, because I get to now see the issues you all are grappling with, and I'll try to tell the council what you're grappling with. I get it. I didn't get it before.
I appreciate that. All right. All those in favor?
Do we have a second on that?
Yes.
Who was
Paul.
All those in favor?
Aye.
Aye. Opposed? Okay. Very good. Thank you. Now, we need to deal with the definition. The definition is 64 dash, what is it?
18.
RZ 10-08 and 64-1, the definition of a landscape business.
And I don't think they really had a lot of question about that, other than whether or not we allowed residences.
No, they didn't. I mean, my personal opinion of this is it's clarifying versus what's there now. It serves the purpose, in my opinion, of causing some of those, and Robin, I don't know whether you've got any numbers on this, but or Glenn, I'm sorry, but it causes some of those, let's call them operations that are out there now that are have been flying under the radar as not having to come forward for a use permit to now have to come forward for a use permit because they are doing what we are now capturing within the definition of landscape business. So to me, there's some positive value in doing that. If the council decides that they're going to limit it to C1, it may be a moot point, but
I think it's still good to have a definition, whether it's just in
Agree.
C1 or not, so.
So, any discussion that we need to have with respect to the definition itself, 64.1?
Just,
Joe?
if I may, and it doesn't really matter one way or the other, I think, in the whole scope of things, but originally we had services described, locations other than landscape business owner's property, and words remote and off-site have been added. And I'm thinking that's probably not really necessary. If they're locations other than the personal property, then they are off-site.
Who's suggested changes to those? Are those
Mine.
Yeah.
That's the attorney's.
So you want to explain yourself?
No, it was adding words for the purpose of justifying my existence.
Finally, the truth.
This isn't being recorded, is it? You know, I could see striking remote. I tell you, I do like off-site locations. In fact, I seem to recall that Councilmember Lusk had a concern and was not terribly happy with the last part of that, which was the landscape business operator's property. And I've been thinking about that while we've been talking about some other things as well. And I wonder if there might be the need to clarify it. Because what we're talking about is there's a piece of property that gets the cup. That gets the cup. That's the property we're talking about. The business owner could own multiple properties throughout the city of Milton. We're talking about you do business somewhere other than where your cup controls. That's what we're talking about. So, I mean, it is a little tricky, but
Operator's property versus owner's property might be misinterpreted too.
Right. So that was the only thing Councilmember Lusk, that one comment stood out to me because he indicated, what does that mean? The landscape business operator's property, which property is that? What if he owns multiple properties? And of course, you can get ad infinitum, these sorts of hypotheticals and make your ordinance seem sort of silly. But maybe what we need to say is it's that you're doing business other than the property upon which you have a cup. That's the point. It doesn't matter whether he owns it or not. It just matters where the cup is located. That was my only concern. Remote, council member, I'm sorry, Kramer, I can strike remote.
So to my point then, Ken, do you think we need to better define the operator's property versus owner's property? Do we get in trouble there?
Or just call it the landscape business site.
Quite frankly, you could almost end the sentence at the word locations. A business providing services described below take off remote at off-site locations, period.
That'd work.
Yeah.
Maybe less is more.
Yes.
Yes, that's good. And I certainly agree we need to keep the word such later on.
Yeah. I just missed that.
So with that change, the first sentence would read, landscape business means a business that provides services described, and I would prefer to say herein, not below.
That's fine. I'm fine with that.
Herein at off-site locations, period.
Yes. I like it.
And the rest of it would be as written with the word such in there.
May I make one comment?
Sure, Curtis.
Ms. Maloney and Ms. Peters, my question is no longer relevant. So just in case, because I'd asked to be able to ask you one. I'm not gonna ask. So I just want to make sure you don't stay.
Are you dismissing me?
Curtis Mills dismisses public attendees. No,
Okay.
I just didn't want you guys maybe waiting on that.
Yeah, news at 11.
Did
Right.
you guys have something you wanted to say seriously?
Well, I think seriously want to thank you all, and I know how much time and effort you guys have put in this and how much energy has been expended on it, but just sort of my gut reaction to everything that's been going on tonight is, the Milton is a very special place, that's why we all live here, this is why we live here, but it's, you know, our logo, for goodness sakes, is a horse, and we need to promote equestrian and protect that, and anything agricultural, that's what we all know about this place, and we really just need to protect it. There's, like I said, a time and a place for everything. We need to be business friendly, I get that, I appreciate that, but it needs to be commercial. And the landscaping thing is a commercial business, and I don't want to just belabor the point, but I look to this planning commission to, you know, to do that, exactly, you know, I mean, to set things up so that the residential is protected and the business is what it's supposed to be. But I do appreciate everything you guys do and all the time and effort, so thank you.
Thank you.
We need a motion.
I move that we accept Section 64-1 definitions as adjusted this evening.
Is there a second?
Second.
Discussion? All those in favor?
Aye.
Aye. Opposed? Curtis? Okay. Okay.
Okay. Next item is, I'd like to do an update on the joint work session with the Highway 9 Design Guidelines Committee and future text amendments to State Route 9 Overlay District and new Deerfield Overlay District. I gave you a handout for those who had come to the joint meeting, which was very well attended, and I'm sorry for those who couldn't come, but I think it was a very productive meeting and enlightened everybody on both sides. But it says proposed timeline for Highway 9. Obviously, this is a pretty aggressive schedule, but it's what could happen in the sense of the procedures and what's required by law for advertising and for public hearings. So we had the meeting on January 18th, and then we're going to have a community zoning information meeting actually on February 23rd. And prior to that, I should have a draft of the amendments available for the public. It'll go for a courtesy review by the Design Review Board on March 1st. Come to you at the Planning Commission on March 22nd. If it was approved with no delays, then it would go to City Council work session on April 19th, and then City Council meeting for approval April 25th. So obviously, that's with absolutely no deferrals, but you know how we are. We like to discuss things. So, but again, that would be the plan for it. One of the items that came out of the discussions was that even though the committee, the Highway 9 Design Guidelines Committee, is pretty much disbanded, but George, as well as staff, had invited the members to come to, I think George wants to have a work session at some point. I don't know if prior to that meeting of the same day or a whole different day, to discuss the nuts and bolts of the text amendments. So I don't know if you want to address that, George, about how you all want to.
Well, what we talked about that night for those that weren't there was there are certainly members of that Highway 9 committee that don't want to just walk away from it and hand it off, and understandably so. And I just thought that it made sense to offer them the opportunity to have a work session where it would be basically just us and any members of that committee that wanted to attend. Obviously, it'll be a public meeting, but not to have that discussion at the Planning Commission meeting. Obviously, it needs to be after the text amendments have been drafted and we've had a chance to see them. So my thought was somewhere between the February 23rd and the March 22nd date, we would schedule a work session for the Planning Commission and invite the Highway 9 Committee to attend for the sole purpose of reviewing those text amendments. Why are you
Yeah.
guys smiling at each other?
No, just.
Just happy.
It's difficult. I mean, I'll be honest with you, those folks have been together so long, they're really kind of tired of it.
Well, that's
And-
okay. If they don't want to come
now,
more.
that's not to say all of them are, because there are still several there that,
Right.
probably a handful of the original committee that are still very energized and want to keep in touch, but, it's just a matter of getting, as long as you don't need a quorum of them there.
No.
Then that's
And Curtis, you were there, I mean, and Jennifer was there. In my view, it was just offering them that opportunity, and Paul was there.
Okay.
It's just offering them that opportunity. I wasn't suggesting we make it a kind of a scheduled meeting for them, but just tell them when it is, let them know, and so that they have the opportunity. If they don't show up, that's fine. We're still going to, I still think personally, if we're going to meet anywhere near this schedule, we need to have a work session to look at those amendments. We can't talk about them for the first time on March 22nd and assume that we're going to approve them that night. It just won't work.
I thought they were engaged. I mean, I got the sense they were
But
glad
they
to
may have
be
been
there.
engaged because they thought it was their last meeting.
Fair enough.
Different from what we expect the process to be going forward, and you guys have done a good job of defining what the new process will be. This committee already existed. They got to the point of conclusion where it was outside of the process that we have all agreed to adopt going forward. So, but I think there is value to us having a chance to discuss what's coming before us in a work session forum, with or without those folks. I would hope that they would come, because they did have some very valid points that they would want to reinforce to us, I think. But that's entirely their discretion as whether they would choose to come or not. But I think we would be better served to have another meeting
agree.
outside of a formal
I agree.
planning commission meeting.
Can you guys propose a date so I can throw it out there?
Sometime between February 23rd and March 22nd.
Is there a better day that works? Tuesdays? I mean, that's what I'm trying to find out from y'all's schedule, if there's a certain,
Curtis, what works best for you in terms of a day of the week?
I'm gone that whole the week after that 22nd.
Of February?
It's a spring break. Yeah, I'm gone. I know I'm
it probably wouldn't
gone
be
that
that
week.
soon afterward anyway. I think,
I was thinking maybe like the week of March
after
8th.
after the design review board maybe, so we could get their input too.
Yeah, like March 8th.
Mondays are always good for me. Tuesdays are almost always good. Wednesdays and Thursdays get shaky.
So you want to make it like the 8th? That'll be the week after.
What day is that?
March 8th, it'll be a Tuesday, because March 1st is a Tuesday.
So
Or it could be a
March 7th then to Curtis,
For
Mondays?
Monday, I don't care.
Well, is there a council meeting?
It'll conflict with the council meeting on the 7th.
Tell them to cancel.
Reschedule, yeah.
Let's do the 8th.
Okay.
That's the Tuesday?
Yeah.
All right.
I will be
Will you guys-
at a 6th grade band concert, so I'll miss you all.
What about the next night, Wednesday?
That's fine.
Curtis, does it matter to your schedule whether it's
Thank
8th or
you
9th?
thank you for even checking, but let me have a look. Every other Wednesday is a commitment for me, and
I missed the first band concert, I can't miss the second one.
Lord, I'm the last guy in North America with a trio. I can't make it work.
They don't make those anymore.
You may be the last guy using a stylus.
Czechoslovakia only.
It's an antique.
Yeah. Well, Curtis is kind of
I'm sorry. Okay, here we go.
You didn't have to pull out your big appointment book like Fred did.
That's right. My calendar book.
All right. It's the Wednesday. It's the 9th.
Get him an iPhone or something.
No, it's actually the only smartphone that doesn't require you to have email. I get hundreds of email a day, and I just don't want them beeping. And it's the only one I can get that lets me do calendar and all that, and I don't have to have email, because, anyway.
I have a Motorola product I can suggest for you to use.
No, that's good. What's that?
Does the 9th work,
The
Curtis?
9th is good. What'd you say?
He has a Motorola product to suggest for you.
Still loyal, even though no longer.
All right, the 9th.
Okay.
The
7
9th.
o'clock?
Yeah. You want to make it earlier? That's fine.
No,
I'd-
7.
Yeah, personally, it works better.
So Wednesday, March 9th,
Right.
7 p.m.
Okay, great. Sounds good.
Okay, we got one more item, and that's just an update on the overall plan, which Robin handed out earlier, right?
Yeah, it's Lynn's.
Yeah, actually, I handed that one out.
Got a comment or a question?
I got a comment, question for the group.
My name is Vince Catanzaro. I live at 565 Devonshire Farms Way here in Milton, Georgia. I am here as a volunteer on behalf of MDAC, the Milton Disability Awareness Committee, and just wanted to ask the question. It seems like it's an open forum on the overlay districts, and Deerfield wasn't brought up in the update because that was all Highway 9, that update. Is that correct?
Well, it would include Deerfield, that's the edits, we're going to create a Deerfield overlay district.
Okay, so that's new. Okay. From an MDAC perspective, I'd like to have MDAC participate before it goes public so we can get an understanding of what the overlay looks like and you know, how that would align to the goals of the Disability Awareness Committee. Also, just to make an additional comment that George had brought up, I'm also a horse owner and a boarder of a horse. And the comment was made, I'm not positive this is correct, that there's no licensing required for the horse farms to have a license to conduct that business, which I'm assuming means that there's no fire marshal inspection. And I just want to make the recommendation to the board to put that on your 2011 agenda because, you know, at some point there could be disaster and some children get killed in a fire, and it can come to people's attention that the city of Milton knows that there's commercial businesses being conducted without licensing and inspections required, and it could be a liability issue. So I just want to make that recommendation to the board as well. That's it for my comments. Thank you.
Appreciate that. Just let us respond at least to the first part of your comment, and I don't know whether you meant that literally, but you know we don't have any opportunity to look at these things before they become public. They will be public. Certainly we can engage and invite anybody. I mean, all of the meetings that we have are open to the public, so that the MDAC committee representatives can certainly come to that work session as well to talk about that. The guidelines themselves that were developed by that Highway 9 committee or have already been approved by City Council, and I suspect they're already on the website, are they not, Robin?
Yes, they are. The
So-
document is on
So
the
that's
website.
already out there. The text amendments themselves have not been drafted yet, but the guideline document's already been approved.
Is there an opportunity to make comment to those? Like, you know, as a citizen of Milton, I go online, read those, make comment to
Absolutely,
this board, would that
but
be the appropriate
recognize
place?
that they've already been approved by council. This is not up for debate. Those have already been approved. The text amendments incorporating some of those things into the ordinances is what we're talking about now.
Okay.
Those guidelines are already approved and they're out there. Lynn?
The priority project listing, just to give you a little bit of an update, project number 3, the LID practices.
Mr. Chairman, I'm
Oh,
sensitive. I'm
Ken, I
sensitive
apologize.
to the-
Thank you for
to the,
coming tonight.
Thank you. And again, I
Thanks a lot.
No, thank you very much.
Thank you all.
We need to do this more often.
Love Lynn's presentation.
Call it a vacation day, come back.
My praise.
Thanks, Ken.
Project number 3, incorporating LID practices in the stormwater regulations. We have actually looked at potentially incentivizing those LID practices in, particularly in residential developments. We have looked at a couple other municipalities and some recommended by the Planning Association as well. Jimmy Sanders is leading the work on that in cooperation with myself and Carter Lucas, our Public Works Director. It's brought up some interesting points and some interesting observations of things that are already available to us through the Georgia stormwater what they call the Big Green Book, which is the state stormwater code book, and design regulations that people just aren't using, maybe because they've never had to think about using them. So some of the options are already there. They're just not incentivized enough for people to really consider them. So worth looking at it from that perspective, and so that's ongoing. The conservation subdivision ordinance, Mr. Moore, I believe that you had asked to be included in on that. That has not necessarily started at this time, but what I've handed to you.
Actually, that's not true. The three people, and Paul certainly
Okay,
can be.
I'm sorry.
No,
I only
Paul
remember
certainly,
Paul.
Paul certainly can be involved, but the three people that said they wanted to be part of that were Chris, myself, and Curtis.
Oh, well, I totally messed that up. Thank you for correcting that.
I get confused with Paul a lot.
Like I said, I wasn't trying to
Happens
exclude
all
you.
the time.
I went back to my original notes for this thing. It would be
Pass those
helpful.
down, Paul. No, I'm kidding.
It would be helpful if we could
Yes.
capture that somewhere, because I'm not aware of anything going on with that, and Curtis and Chris obviously aren't either, so.
Well, and like I said, what I just handed. Well, what I handed to Paul, and we'll hand to you all, and send out probably in the mail, is a copy of the ARC's Conservation Subdivision Model Ordinance, which is probably a little looser than we would like, and a copy of the Conservation Subdivision Ordinance. It's a model from the Etowah Habitat Conservation Plan, which is probably a little tighter than we would like. So somewhere in between is a happy medium. There are others as well, but I thought if we could start with those two, since they're kind of already out there as models for Georgia, and particularly for North Georgia, that we could look at those first and kind of highlight some of the things that we like the best out of those that we'd like to keep, and then start with that premise.
Why don't we just, let's forget what we did before. Let's just clarify tonight for the sake of Lynn, who wants to be involved in that one. And I don't want to
And I apologize for
recommit
messing
anybody.
that up.
So we're talking about the Conservation Subdivision Ordinance. I want to be involved. Who else? Paul does. Chris does. Curtis, yes or no?
Sure.
You don't have to. I wasn't trying to usurp
No, I
your...
understand.
Okay.
It's important.
Okay.
I don't have a lot of time, but I'd like to be involved in that.
Okay, so you got 4 on that one.
Okay. Will do. Oh, shoot, wait a minute. That's a quorum.
Yeah.
Can't have a quorum.
Can't have a quorum.
I'll cede my position to Commissioner Moore, my twin brother.
Well, we know which one's Danny DeVito.
That's right. That's exactly right. That's exactly. I almost said that, but
Go ahead, Lynn.
All right, then. So now that we don't have a quorum, yes, we can even meet separately. So
Okay.
I'll send that out to you all. Again, I apologize. Moving on down, the next project that's underway is Project 10, amending the sign ordinance, and I believe as late as yesterday evening, there was another meeting, and they have narrowed down their subject matter to the top 5 issues that they've identified to address.
And that's Paul and Jennifer.
Yes, still
Yes.
is.
Okay. Any third person interested in that one? Okay. Still Paul and Jennifer.
I could just give a quick update. We met yesterday, and to Lynn's point, we did identify the top 5 areas that we're targeting, but in no particular order at this point. They include the assessment of our current regulations on banners. That's one of the 5. The second is a master signage plan for commercial developments. The third is a measurement of the commercial and residential real estate signs, a measure of what our current requirements are. The fourth is community identification banners, which would include like areas like Crabapple that want to identify themselves separate and apart from.
And historic preservation districts.
Well, we talked about that as well, actually. And then the fifth is additional prohibitions or enforcement issues, just as a broad brushstroke. So those
Sounds
are the
good.
5 areas we've identified
Sounds good.
that our project team is going to work on.
So neon signs fell off the list.
It's in there. It's basically, that's part of commercial, residential.
Okay. Good.
Signage, master signage for commercial development.
Sounds good.
Number
Are you
11
feeling
is-
better about?
No.
things, no? No. Okay.
All right, Paul, we can talk about that afterwards. The next project would be completing the landscape business use revision, which we discussed tonight, so hopefully,
Our part is
assuming all
done.
goes well, we might be able to get that done.
We're ahead of
by
schedule.
The end of March.
We're not supposed to be finished in November.
Number 14, text amendments for green communities designation, and that's one I think that Mr. Kramer, you had asked to be a part of.
Correct.
Joe and I
frankly-
both.
I'm sorry?
Joe and me.
I'm putting both your names down. Okay. That one has been a bit delayed, partly due to the fact that our planner handling that is pregnant. And,
Who's that?
but we'll.
Michelle.
That's Michelle.
Oh, that's yours.
She announced, well, I mean, she didn't announce it,
Not
but we
your
found
fault.
out right before Christmas.
Not supposed to be in my plan.
But we will get started on that fairly quickly. I think, like I said before, when we first introduced this, a lot of these can be handled rather quickly. There's kind of some policy issues versus text amendments, so. Moving further down, under other staff projects, please note that number 18.
You skipped 15. 15 is Fred.
Fred's isn't scheduled to come up until March.
No, not till March 1st,
Oh,
11.
oh.
Yes, that's
Oh,
what he
it's just a whole
said.
month.
She's just covering the.
Fred's
10.
already done.
This is going to be called the Edwards Amendment.
And Fred's done, fabulous, and
I have-
we'll, okay, well then, let's hold that till March.
We'll have two more by then.
Just draw a big circle with a line through it.
Moving down, Project 18, complete the Highway 9 Design Guidelines Project, which is what Robin has recently gotten approved with the council. And number 22, the joint LCI grant application with Alpharetta. Our planner, Ms. Ross, who's the lady who was pregnant, finished that for us as well and got that done very quickly, I might add. We're hoping that, just so that you all know, we're hoping that that will cover our Highway 9 master planning. That grant request was for that, those monies, so that maybe we could reallocate the monies we had initially planned for that. So that would be really a good one for us to get. It's a good bit of money.
When will we hear about that?
This spring, so
Okay.
somewhere around March, which I believe we had planned the master planning corridor to start in May, which is not ideal for Ms. Ross. I believe that's when her baby's due, so.
So how does that differ, Lynn, than the grant that they were talking about in the paper? I guess that's going to expire in the next couple of years.
That's a T grant. That's a Georgia DOT grant. That's a TEA grant, Transportation Enhancement Act grant. So those are primarily for streetscapes, and those typically follow the LCI projects. So if, for instance, this LCI grant goes ahead, and we have the grant monies to do all the consultant work for this master plan, it would include streetscape and other enhancement issues for Highway 9. We can then apply those almost immediately.
Okay, that's what I thought.
Those
All right.
monies to that area. So that would be kind of fortuitous, although it does move those monies from the Crabapple area.
Okay.
And I think it's about $500,000 so, from the T grant. So that's, there again, that's a lot of money that would be invested in that area in a short period of time. We're moving down, number 28, preparing an economic development plan for Milton. We submitted a UGA practicum request through their College of Business, I believe it is. And a lot of the projects that have been awarded have been to other areas. This year we have gotten one. Mr. Frank Arden will be coming to help us for, I guess 3 months, maybe a little less, to finish this project and get us our first baby steps into a true economic development plan. So I'm hoping to introduce him at a planning commission meeting as well. So.
Great.
And I just found that out today.
There was a lot of talk back during the elections about the creation of an economic development committee. Would that be a likely outcome of that as well?
There would be some analysis as to whether or not we need an economic development commission or committee versus whether or not we use incentives on our own to include those things. At this point, you know, it's are we creating the wheel or not with the North Fulton Chamber of Commerce and their economic development arm?
Okay. Who on staff is charged, you know, at least on paper, with economic development for the city?
You're looking at it.
Okay.
Number 29, the Highway 9 guidelines and text amendments, including Deerfield. You've heard about that tonight as well. Number 30, the Milton Strategic Planning Team. That's a project, again, that was given to us not by the Planning Commission, but I wanted to make you aware that it was going on and does take up a significant amount of time, and I've been assigned to that project. We're working on a strategic plan for the city that would complete approximately in April timeframe.
This may be a silly question, but any reason why the Planning Commission isn't involved in that?
It's more of an operations plan.
What's an example?
Well, like I said, we haven't gotten to strategies yet. We've been working on vision and mission up to this point.
Yeah, I'm not trying to be sarcastic,
I understand.
but if we've defined ourselves as not entirely tactical, and in fact tactical and strategic, so does it make sense to have someone who's on that committee? I mean, who's doing that?
It is a group of department directors as well as some citizens from around the city that represent the key stakeholders that they initially identified at the last retreat. So there are folks who are from the business community, folks from the equestrian community, folks who represent families with young children.
Can you name who's on the committee? Or
Sure. And there are 15, so you'll have to pardon me if I miss any. I'll start with the folks that are out in the community. There's a gentleman, Scott Spielberg from Milton's Cuisine and Cocktails. There is, and he's new to Milton's Cuisine, but not to Milton.
Is that Milton's Restaurant?
Yes.
Yes.
Mm-hmm. Yes, there's Mike McAlpin, a longtime resident. There's Rita Moore, who is, you might remember from the state disabilities coordinator.
Yeah.
There's also, I'm trying to remember all the citizen participants first. There's one more.
Who's from the equestrian committee you mentioned?
Oh, Jack Flowers. Thank you very much. That came to me. Jack Flowers from the equestrian community.
Who picked these folks?
They were picked by the city manager in cooperation with council. The strategic planning, the folks who led the planning retreat were aware of those folks, but of course they don't have any knowledge specifically as to the persons.
Is it being facilitated by the same people that did the retreat?
It is.
What's the cost?
I have no idea.
And what's the objective of the thing?
Again, it's a strategic operations plan for the city. So again, and that's part of why there are quite a few of the department directors involved.
I don't know. I don't know what that means, strategic operations plan.
Like I said, we'll be looking at mission and vision. As part of that, we'll take on potentially some of the items the Planning Commission has taken on. I mean, as far as my input will come from your perspective as well as the perspective of the department as a whole.
Mission and vision at a city level, or mission and vision at a department level?
At a city level. At a city level. So
How is that different than the strategic plan or whatever that was finally submitted after, 3 or 4 years or worse?
that's the comprehensive plan.
But I mean, that states a mission and,
A lot of what's included in there
Okay.
will be reflected in the strategic plan as far as that goes, with reference. I mean, obviously, we're not going to recreate all that work.
I can appreciate not including Curtis on it. I mean, like, usually he's disruptive. But is there-
Not just
You haven't met
irritating. Not just disruptive,
You
but
let Paul
irritating.
finish his statement.
That's a joke.
Wait,
But is there a reason?
Annoying.
Is there room for somebody from the planning commission to be on that?
I don't know that there is, and not by design necessarily, simply they had a limit of how many persons they wanted to include, and that those persons would specifically represent these sectors of the stakeholders.
It seems like kind of an obvious statement, so not to insult anybody, but, you know, if the city's doing planning, it would certainly seem that somebody from the planning commission should be part of that.
I'll do my best to represent you.
Not casting stones. I think you're a princess. You know that. But I object. I object to this strategic planning effort and its makeup. And I can't imagine that's a sensible effort without this group being involved. Or again, we're just marginalized. And but not criticizing you, of course.
Understood.
You know,
Just yet another
honestly, you know I mean that.
It's just yet another example.
Yeah. It's like, getting a computer that's just really a broken television. And they never tell you.
All right, the last one, let's just move on. The special event permitting revisions, text and forms.
Well, then, that's the other.
That's something Robin's working on. Robin, can you give them the latest on that?
We have a lot of events that come, a fair amount, a lot of 5K runs, just different, just events in general, and we don't really have a comprehensive application that really deals with all the issues that can come up with. It's very interdepartmental, public works, public safety, fire. So I'm taking right now, we've met with the department heads and creating or kind of stealing a little bit from a community in Arizona. They have a pretty comprehensive directions and form. It's pretty boring. No, it's not boring, but I mean, it's stuff that happens. It's everyday things.
What
Yes,
she
it is.
meant to say.
Madonna fee tonight, yeah.
But it's amazing. It's this place called Buckeye, Arizona, and like 5 of the people out of the 10 people in the room had been there. I'd never even heard of the place before. But anyway, so that's what I'm working on.
And the last one is grant funding, not grand funding, right?
Oh, I'm sorry. Yes, it's grant funding.
I
Slip of the
now,
wrist.
I don't want to drag this out, but what I don't see on here, and it kind of fits in with what Curtis was saying before, where is the work that Lou Oliver's been hired to do on this list?
The charrette, it's not on that list. It probably should be under other staff projects. Primarily, it's for dedicated to crabapple only, but it is a planning document. You will be invited as a stakeholder group to participate in that. It should happen, I want to say it's March 14th, if my memory serves.
And
That week.
what happens to the product of that charrette?
Well, the intent then is for that product to be taken and translated into updates for, as necessary, following the results of that, for Crabapple Crossroads Overlay District.
And what's the process for doing that is what I'm asking. I mean, it's a parallel question to what Curtis asked with respect to the strategic plan. What's the process? We're investing $30,000 to do the charrette. What's the process for taking the product of that and making it into something that's useful?
Well, once it's delivered to the city and they go ahead and resolve to accept it as a design document, then the staff would have to go back and make these changes, of course, through you all, because it would be a zoning text amendment.
Okay.
Which is why you'll be a stakeholder group that's particularly asked to attend.
Can you clarify for me Lou's specific task? Is it design guidelines, or is he redesigning Crabapple?
It's wide open as far as whether or not there's a whole lot of redesign or whether or not there's, what is nailed down, the pins in place are, we have a comprehensive transportation plan that includes specific recommendations for Crabapple. So those lines are on the map. What's up for grabs is redevelopment of any of those areas. We know that a lot of it has been foreclosed on and may or may not be developed as it was initially prescribed. So particularly those areas. Any other city sites that we have there, obviously the schools, we've got a joint department that we've worked on between the two schools, as well as the Crabapple Community Center that's our city-owned property. Obviously, there are some historic sites there as well that would have to be addressed, and are pins on that map along those lines. So, other than that,
And one of the reasons I asked that question
Some opportunity.
is the line number 6 on here, which is the TDR feasibility study, and ordinance doesn't fall until later in the year. And, you know, I'm personally convinced that if Lou's going to have any opportunity for success in working with a new vision for Crabapple that addresses the transportation issues, the property ownership issues, the developer undeveloped land issues, we're going to have a TDR ordinance in place to accommodate some of the things that we're going to be asked to deal with in the likely outcome of any proposals that Lou's likely to come up with.
You say have to have it in place or should consider?
Well, I just think we certainly, I'm suggesting that it's quite likely that, let me say it differently. We all know that Crabapple is faced with a lot of challenges today because of what.
I just
county
mean
did to
I
it.
just mean the TDR.
Yeah,
I'm just
I'll address
curious.
it. So in my comment, so we know that with what Fulton County did to us, basically with the land rush that took place prior to us becoming a city.
Right.
But it took some of the spirit of a balanced Crabapple solution out of the prospect of reality. And along with that, we know that there are a lot of layers to the issues that we're facing in Crabapple. The series of roads that are likely to produce a balance there so we can support business in a logical way to not compound traffic issues, for example. And we know that today's ordinance, binds it to X number of square feet is developable for a commercial office, et cetera. And so it's, to a great extent, it's a mess. And in order for Lou to do the quality of work that we know as evidenced by the work that Lou has done in his history, some of those parameters are going to have to be revisited. And
Well, but
I
a
just think there were-
TDR is one way to do that.
TDR is one way to do that.
Yeah.
I'm not suggesting it's the solution, but without
No,
an
I mean,
ordinance
I'm
in
personally a
place-
believer. I've been involved with that in Roswell. In fact, I've got a couple of, at least one pretty good document on TDRs if anyone's interested.
So without an ordinance in place to allow for it to even be considered, we're to a certain extent tying Lou's hands with some of the likely solutions.
I think that we have actually given him the leverage to set the stage for the TDRs. Between that and the recommendations of the comprehensive plan, which are already out there. So I think that's given him and will give him enough leeway to make the recommendations he needs to make to accomplish the vision of that charrette.
And it's great if we say to Lou,
And then
clean
part of
slate,
that'll be-
have at it.
Well, it
But I
would
don't wanna
be
create a
hard to
false-
keep Lou inside a box, no
Exactly.
matter.
Well, I also don't
no
want
matter
to create a
what.
false sense of expectation for the community, good, bad, or ugly, with what the outcome is going to be. If we
Get a
know-
plan that can't be implemented.
Yeah.
Yeah,
Well,
right.
I think
Right.
again, once we get that deliverable, then we start putting together the Gantt chart of projects that makes that implemented.
Curtis and I are still, hurt that we were unable to get approval to hire Lou and others were,
We,
We tried to make.
we
this
actually went to pretty great lengths. We met with him offline. We made specific pitches to your two predecessors, one of whom was a princess. And I'm kidding. Alice would laugh. I call her princess now. But no, they shut us down. They shut us down. Didn't even want to talk about it. More Tom, I guess, than Alice. Yeah, it's not fair because Alice came in kind of after the fact, but it was money, and it really would have been money well spent at the time, and we just threw ourselves up against the door and
Well, I don't have that
never got
history.
any traction.
And maybe that has
No,
helped
it's like,
us.
it's like the sandwiches, right? Okay. Anything else for the good of the cause this evening? If not, we need a motion to adjourn.
So moved.
Second?
All those in favor?
Aye.
Anyone opposed?